Mention item number 5 of today's list, Lordship. Lordship, we have some difficulty today. Only Passover for the day is my prayer, Lordship. Item number 5, hearing matter, Lordship.
No, five is an old matter.
Lordship, only for the day.
Why? Which,
Lordship, actually, some hearing matters has been fixed in court number 1 today. So I may pray for at 2, but my senior may be on legs that time.
you do it.
Lordship, I have tried, but this is a bit complicated matters.
I find it difficult to grasp the matter without the assistance of your senior. And obviously, I'll adjourn it.
Lordship,
Okay?
I know.
No adjournment. Next.
May I please? No, I pray for listing of pending cases, man. Whoever might have granted the stay, madam. Regarding the selection of a service proper in a retail outlet, madam.
Huh?
Might have granted the stay, madam, in the selection procedure of a service provider in a retail outlet, madam. Might have granted stay in the selection process, madam. So
I've granted a stay.
yes, madam.
Then obviously there must be good reason.
Yes, madam. There is sending circumstances, madam, we need to cancel the entire selection process, madam. The person decided, madam. So, madam, it may be taken up before 31st of October, madam. So the existing service provider will expire on by 31st of October.
Friday? Tomorrow?
Yes, but tomorrow, madam, I have some problem, madam.
When do you want it?
Madam,
We'll open the High Court for you during the Diwali. Huh? Tell her. You have difficulty.
Madam, I have a case in November, madam. That's it.
Have it in the month of November.
No, madam, on by 31st, madam, the existing madam, the service provider will expire by 31st. Before that, madam, I did it, madam.
Okay, 27.
Maybe resolution. Motion matter, my lord. Filed on my lord, 1410, my lord. And then
Tomorrow.
tomorrow, my lord. Obligation.
Similar prayer, Lordship, on motion listing, Lordship, tomorrow, Lord. Therefore, listing of a motion matter tomorrow, your Lord.
I would have also prayed the same, but I must be fair. The filing is going on and the scan part is not yet over. So I'll miss the mention if I am making a prayer, if Lordship allows, I can fill up that number in a while.
Tomorrow.
With the consent of the others, petition, since you get development of the mention item number 1. It is matter meeting was held, however, for yet to issue. So 1 week or 10 days may be granted for issue that clarification.
Item number 1, you want an adjournment? Why?
My lord, corrigendum has not been yet.
In fact, on 10/3/2023, a notification was issued wherein the municipality tax said to be 25% from the previous rate. Now, they have relied upon that while calculating the tax. Now they say that they will revisit that notification in earlier occasion. But that also takes 3 to 4 months, my lord, earlier occasion.
It has been revisited and subsequently they adopted that they require some clarification, and by that original.
When do you want it?
Okay.
When do you want it?
17.
It is up to the government when they will issue the origin. The meeting was held already, but
When?
After Diwali, 10 days.
Then 3rd or 4th, my lord, November. Any day.
3rd of November?
Okay.
At the request of Mr. G. Bokiel, the Learned Council appearing on behalf of the government of Assam, matters can be adjourned to be listed on 3rd of November.
May it please, your lordship, I beg to mention one writ petition for withdrawal.
I'm sorry, my lord, interim order is there.
The interim order passed earlier shall continue till then.
Get good.
Lordship, I beg to mention one writ petition for withdrawal, lordship.
When?
Tomorrow, lordship.
I'm paying for adjournment of item number 2 and 10 because BTC is a party and it was Mr. A.K. who has been recently appointed as senior standing counsel and files were not asked. So I'm paying for adjournment of 2 and item number 10.
Why?
Lordship, because Lordship, files were not with us and recently on 14/10, the AKB has been appointed as senior standard counsel.
So for how long all BTC matters required to be adjourned? Give us a good date.
Only 1 week or 2 weeks, because files were not with us and we are really engaged.
Item 2, who is appearing? Have you asked, informed the other?
They've taken consent of the other counsel.
Item number 2. Why the matter is fixed at 2 p.m.? 2 and 10. Be listed on 18th of November. At the request of the council appearing on behalf of the BTC, matter stand adjourned to be listed on 18th of November.
Top of the list, item 11, part heard.
Yes, what has happened here? Because if I remember correctly,
Yes, well,
there was a direction for correction of their name.
correction of the names, yes,
Now you are asking for some premium.
yes, payment because correction of.
And
the-
what was the case about the tenancy case? 80 of 2021.
Because, my lord, I have received this voluminous instructions. This says, my lord, that originally it was a royalty land. And the classification of that land was not changed. Nonetheless, my lord, it was sold.
What is the royalty land business?
It was,
There is a riot.
right, yeah, but, my lord,
Maybe Katiyan may have been issued,
it was a.
but the
part of
owner remains the owner.
The owner remains the owner,
But the transfer was made by the owner.
yes,
So then where is the question of royalty land or not royalty land? The royalties will become, the royalties who are there,
yeah.
they would become the area of this owner. But how does that have to do anything with the premium to be paid by them?
They say, my lord, the department say, because, my lord, the district commissioner has, my lord, asked for depositing the rupees of 23 lakhs and on amount on the basis of, my lord, calculation of zonal value of 10%.
Tenant was Brigadier KP Lahiri.
Yes, this is what it comes from the instructions in record. If I may read it, my lord. From the second paragraph, it is to be mentioned as per Deputy Commissioner Kamrup Metropolitan District by order dated 121 in persons of so and so had accorded an approval for exclusion of 1 bigha 1 kotha 2 lesa of land covered by so and to restore the FS grant along with the name of original Pattada Mohendra Mohan Lahiri and also to restore the Khatiyar number 35 against the same.
Who was the original owner?
Original owner, my lord. Brigadier, my lord, it will be, my lord, original owner will be Mohendra Mohan Lahiri because it is stated that he was the original Pattada. At paragraph 2 of this instructions, my lord. I'm reading paragraph 2, my lord, from the first page.
Huh?
My lord, this bunch of instructions, my lord. I'm reading paragraph 2, my lord, the second paragraph.
Don't go by that paragraph 2.
Chronology of events, my lord, have been found out here, my lord, in my instructions.
because my lord, from whom they have purchased, Brigadier K.P. Lahiri, he was record, his name was.
No, on
record-
what basis are you saying that, let's see the sale deed?
Well, in the instruction it is stated.
Yeah, in instruction, I don't understand what it is.
In the instructions, my lord,
How is a retired army officer an occupancy tenant?
that is not known, but it was there on the basis of record. Therefore, if lordship may be pleased to take up this instruction at page 14, lordship will find a schedule in the sale deed. That sale deed has been annexed to the instructions, my lord. The schedule says, my lord, one-storied Assam type house consisting of 14 rooms, including bathroom and toilets, kitchen, store, pantry, electric fitting, light and electric so 6 servant quarters, overhead water tank, and all other structures on 2 bighas of land, more or less, of dark number 24 old so of Khatian 35. Possible kindly mark this. Of Khatian number 35 of Vasistha Grant under jurisdiction of service. So it was this brigadier, my lord, K.P. Lahiri, from whom, my lord, their predecessor in interest had purchased, that land was classified as a Khatian land. Now, and it was a, my lord, agricultural land, naturally, my lord. Now it has to be changed to homestead land. So therefore, in the year 2024, there is an amendment in the, my lord, 1971 Act. That lordship will find, my lord, at the last 2 pages of my bunch of instructions. There it says, my lord, section 23, after new section 23A has been inserted, my lord. Lordship will find it at the last page of my bunch of instructions, my lord. The last section. In the principal act, after section 23, the following new section 23A shall be inserted. 23A. Any occupancy tenant who are in continuous possession of such land and whose names are recorded in the record of rights of tenants as per section 55 of the Act and whose land has been subsequently included in town land irrespective of present usages of such land, if desires to acquire ownership of rights, may at any time make such application in such manner as may be prescribed to the district commissioner and on payment of compensation as per section 24 of the Act. And on such application, the district commissioner, with the prior approval of the state government.
Are you therefore saying that Brigadier Lahiri sold the land in the capacity of a Khatian holder?
This is what my record says.
No, show me the records. What does your record show? Not what these instructions are.
Yeah.
I'm not concerned with the
Yeah,
instructions.
first of all, lordship will.
The instructions you make, whatever.
First of all, lordship will kindly see the sale deed. Kindly see the sale deed.
Sale deed.
Yes.
Sale deed, I have seen it.
Yes,
What is it?
Yes, sale deed in the schedule. Kindly see the schedule. The property has been described in the schedule.
One-story building along with along with the structure standing over on 2 bighas of land, more bighas of Hima, tag number in one of the number. So the sale was not made of a patta land.
Yes, it was Khatian.
Lordship, what had happened from the instructions that I received from the petitioners, Your Lordship, what had originally happened is that the land was considered as ceiling surplus when Mr. Mahendra Mohan Lahiri had his name as the pattadar of the land. After that, what had happened, this K.P. Lahiri, Brigadier K.P. Lahiri, is the descendant of Mahendra Mohan Lahiri. Since the sealing case was there, he was considered as a rioter in that case. Because he was considered as a rioter, in the writ petition, Your Lordship may find in page number 41, there is a typed copy. The typed copy clearly states the name of the pattadar has been struck off and the name of Krishna Prasad Lahiri has been entered in the rioters schedule. Lordship, because of this, the whole issue has arisen, where the name of the name of the patta, which should have been reflected as a pattadar, is reflected as a rioter. And because of that, this whole issue of the land being sold as a Khatian land came up to be. Because in the record, it always stated Khatian, because the records were not corrected. Lordship, there is an order of the secretary of the government of Assam dated 19th of August 2020. If I may please share with your Lordship.
It is already there in my bunch of instructions, my lord, annexure B.
The subsequent, after the passing of the order of this writ petition, your Lordship, in 2017, this order came up. Lordship may have a look at page number 3, your Lordship. The second paragraph, your Lordship. This states, Lordship, in the fourth paragraph, your Lordship, if I may read.
Yes.
Lordship, that it is seen from a petitioner available in the office file submitted by Brigadier. Lordship, in the fourth paragraph of the third page of this document that I just shared, your Lordship. Page number 3, your Lordship.
Yes.
That it is seen from a petition available in the office file submitted by Brigadier KP Lahiri, the recorded tenant before the Deputy Commissioner, that Brigadier KP Lahiri was given Khatian in the year 1971, and he had previously applied for ownership right over the said land also. However, it does not disclose the fact that Brigadier KP Lahiri was supposed to be the pattadar. There is a whole gray area left out here, to my understanding, your Lordship, because of which this whole issue of rioter has arisen, your Lordship.
Now, how do you have the connection of Mohendra Lahiri with KP Brigadier Lahiri?
Lordship, that document is not there on the records. However, this is only a verbal confirmation that was given to me. Therefore, as of now, I do not have any document to prove that, Your Lordship.
No, anyways, in the record of rights, somewhere, father's name is always mentioned.
Son of Upen. Page number 42 of the writ petition, Your Lordship.
Hmm?
Page number 42 of the writ petition has a copy of the Chitta of Bosistha grant, Your Lordship.
What is this page 24? Mr. Bapujari,
My lord.
page
Yes,
24.
Yes, page 24 of my instruction.
Peter, read this, page 24, it is not legible.
So the lordship will turn to page 25. It's the riot or Khatian, page 25. There, lordship will see Srimati Satyavati Goswami.
No, not that. I'm not on that. Where is the name of
Yes, Krishna Prasad, page 24, lordship, may kindly see once again, madam, page 24. It is rather illegible, but and the left hand column, lordship will find it. Rioter, Udhikaran, Nam. Sri Krishna Prasad Lahiri, Pita.
Uday or something?
Yes, there or something. So it is there.
But this order of the governor of 2020 shows that this particular plot of land, which is dark number 24, have been allowed to be retained,
Allowed to be retained.
meaning thereby it becomes a part of the land of Lahiri,
Lahiri.
the original Lahiri.
Yes, originally. So it didn't flow into the ambit of ceiling surplus.
Didn't say. So this was retained.
Yes.
If this was retained, then it has to be on the basis of some patta.
Yes, on the basis of some patta.
Patta has to be there. Because if it is the land out there, it has the patta has to be there.
Yes.
It was retained.
Definitely. Yes. Patta has to be there.
And if that patta is there,
Yes.
and if there is a connection of this Lahiri with this Lahiri, if there is some connection of there, then it would be actually a sale which have nothing to do with going for payment of any premium.
So that is correct. But
See, then the question of payment of premium of 23 lakhs or whatever may be does not arise.
it does not arise. If it is found, my lord, that this part and parcel of land could not have been included in the Khatian, rather it is a land, Nyadipatta land simpliciter, then, my lord, this exercise will become migratory. But the fact remains, my lord, what has been transferred was a land under Khatian.
You see, it was done at the time in 1983.
Yes.
The transfer was made in the 1983. But this particular dag of 24 was allowed to be retained. So therefore, although initially in 1976, wrongly it was mentioned to be a ceiling surplus land. If you see the opinion of the order which has been passed
Yes.
of 2020, kindly see the third page, fourth page actually.
Because kindly appreciate,
2, 3, 4.
this 2020 order was passed in compliance of the order passed by the report.
Understood.
Yes.
Now kindly see the fourth page.
Fourth page. Yes, my lord.
The relevant extract from the views offered by the Director of Land Requisition and Acquisition Reforms on 30/3/2013.
Yes.
The above plot of land was purchased by the mother of the petitioner and so and so. The above plot of land consists of an old residential building with a total number of 14 rooms previously belonging to the earlier proprietor of the above land, namely, see, late Mohendra Mohan Lahiri.
Yes,
The house was built during the British era.
yes,
The above plot of land measures 2 bighas was wrongly included in the final statement for acquisition of total area of so and so.
yes,
As per the fixation, the proprietor land from whom the land was acquired under AIA was allowed to retain land where permanent buildings were situated.
yes,
But in the above case, it was observed that in spite of the fact that there were buildings standing in the land measuring 2 bighas, the said land was shown as ceiling surplus in the return prepared by the land record staff.
well,
There is no doubt that there are serious error has been committed by the landlord in this regard. In view of the fact mentioned, I have the opinion that the case of the petitioner for exemption from ceiling land in respect to the land mentioned is a fit one for being considered by the government.
yes,
That as per section 4.2 of the so and so, land under special cultivation or so and so and so and so so and so were allowed to be retained by the tea state. The land of Bokisto ground which were not under special cultivation of tea were treated as excess land and hence acquired by the government under the Ceiling Act. However, the land covered by this is very
yes,
24 by 186, whereby where the building of the proprietor stood should have been allowed to be retained by the proprietor, namely Mohendra Mohan Lahiri, being the land used for purposes ancillary to special tea cultivation. That the said land was purchased by Sri Prasanta Goswami and his mother before the land was acquired under the Ceiling Act, and as such, the land has been used for purposes ancillary to special cultivation. The prayer for exemption from the so and so deserves consideration. Now, therefore, after considering the prayer, it is directed that 1 bighah of land so and so, which was subsequently made ceiling in so and so, was actually used for purposes ancillary to special cultivation and should have been not been made ceiling surplus be exempted here. The Deputy Commissioner shall pass order for reopening and so and so from the area declared as ceiling surplus and restore the land in the name of the Patada and also record the same name of the tenant as retainable portion as regards the remaining quantum of land over the above so and so. Deputy shall examine whether the land for under retainable area is so and so. It is further directed the Deputy Commissioner shall dispose of the matter regarding the prayer for the petitioner for title mutation as per the Assam and so and so.
as per the provision, so this was done, but perhaps, my lord, because of the observations made, findings recorded in this, in my lord, order, speaking order, which was first in pursuance of the writ court order, that the authorities have proceeded in that manner, my lord. Because Lordship will kindly appreciate, if we bring the contours of 1971 Act, then they will have to pay, my lord, 23 lakhs and odd amount. This is precisely what has been called out from the exercise. If we do not bring it, my lord, they are not equal to. Only to that extent, my lord, that finding has to be, my lord, maybe examined by your lordship.
Lordship, with regards to the premium, Lordship, what had happened after passing of this order? The circle officer had written to us stating that we need to pay a certain amount of premium so that the land may be mutated to our name. Us not knowing any better and in bona fide belief that our land will be mutated to our name, we had paid a sum of 2.5 lakhs or 2,28,000, if I believe is right. 228. During that time, this was the premium that was called for. I have a copy of that for your lordship. And this premium that was paid, it was assured to us that the land may be mutated to us. However, after that, 2 or 3 different deputy commissioners and officers changed, and we have been pursuing the matter, but the same has not been done. After which, in 2024, a new act came where the premium increased. Now, what they're asking, to my understanding, is an increased premium, a premium which we have already paid. However, if the premium is already paid, the mutation should have been given to us, considering if it was a ceiling surplus land, or considering, sorry, it was a land which is under your lordship. I apologize, your lordship. If it was a land which was considered to be a ceiling surplus, and then it was considered to be a Khatian land, where the same was under a possession of a tenant. Even though we should have been given the patta, but we were not, your lordship. Now they're asking for a premium which is exorbitant in our opinion, your lordship. Now the only thing that your lordship may like to decide is whether, as your lordship had rightly pointed out, the record should indicate the name of Mohendra Mohan Lahiri against the said patta number and dag number. If records older than 1975 can be called for by your lordship. Lordship, even in the writ petition, your lordship, page number 41 has a typed copy of the same, of the 1970 copy of the Chitta of the Basishtha grant. It states that the land is Bhabari, meaning a homestead land where people reside. If it was a Bhabari land, it should not have been included as a ceiling surplus land. Also, it could not have been a land which is Khatian in that nature, because he was residing there. And to my understanding, Krishna Prasad Lahiri was a descendant of the same. So thereby this whole
You have to show me some link
lordship,
of both of them together.
lordship,
You show me some link,
Lordship.
then I can hold it.
lordship,
They're taking into account that this is an exempted area, land
Lordship.
which was there.
lordship,
So therefore, it was a sale which was made by the owner.
owner. Lordship, some time may be given. I may consult with the petitioners then if they can find any link associated with Mohendra Mohan Lahiri and KP Lahiri. If they may have any documents which can provide, or if they can find some which may create a link between them, that would help in deciding this matter, your
I
lordship.
have found the answer, but it is something like this, madam. Because this tenancy case of 80 of
Because
2021
the
was.
problem is the sale deed does not contain the father's name.
It doesn't contain,
Contain the
but lordship will kindly.
KP Lahiri's father's name is not there in the sale.
It is not there, but nonetheless, my lord, they have already paid. It is their evident case, my lord, that they have already paid rupees 2,28,480 for conversion of that Khatian into Patta in pursuance of that order. Now, this problem of rupees 23 lakhs has arisen because of the amendment of the 1971 Act. Now, this is.
But this has happened now.
Yes, now, that's what.
This has happened now.
Now.
So how will you apply now this particular?
Therefore, lordship, that is the direction, and my lord, ask the authorities not to, my lord, direct the petitioners to pay that amount, because this last page of my petition, of my bunch of instruction, if lordship sees, my lord, this amendment itself come into force at once. And this was, my lord, on dated 27th of September 2024. Now they say that this honorable court has passed an order in their favor in the writ proceedings. Pursuant thereto, the stripping orders have been passed, and the process of issuance of process of granting mutation and issuance of.
Because this amendment of 2024 happened recently. Earlier, the amount which was to be paid was a very minimal amount
Minimum amount and
as per 23.
yes, therefore, lordship will kindly see, my lord, kindly see last but the third page of my bunch of instruction. This will clear the whole matter. Annexure K.
Now, one thing you have done good is increasing the amount, because what was otherwise happening is these people were getting it at peanuts.
Yes. Riot, my lord, he claims ownership, he gets ownership.
And that too after 5 years.
5 years, and the compensation.
No, not in your case,
understood.
but this is what is actually happening.
The 1971 Act doesn't put any embargo, but once I become a owner, my lord, under 23A, I can sell it for non-agricultural purpose. This is the misuse of the 1971 Act. And the compensation which is given, which is required to be given to the land.
It's also very less.
Very
penal,
less,
Very less.
Very less.
Now is he getting good compensation? Have you amended that?
Yes, that amendment lordship will find it annexed.
No, this is okay.
No.
Any occupancy who is in continuous possession of such land and whose names are recorded in the recorded rights as per 55 and whose land has been subsequently included in the town land,
Yes.
irrespective of present uses of the land, if desires to acquire ownership, may at any time make an application in such manner as may be prescribed, and on payment of compensation as section 24 of the Act, and on such application, the district shall, with the prior approval of the shall declare the occupancy to have the ownership right over the land. Fee for more letters. State shall levy the fee for conferring such ownership to the owner.
Yes. Now,
24 is where?
lordship will kindly come to 3 pages prior to that document. 3 pages prior. Annexure K, lordship will kindly see Annexure K. Now, this is done in pursuance of this amendment. Amendment came into effect, my lord, on 27th of September 2024, and this notification was issued on 16th.
No, what is, where is section 24?
So it is 23A.
Understood. 23 says that in such manner as may be prescribed to the deputy commissioner and on payment of compensation as per section 24 of that.
As per section 24, it may not have been worded as such, but this notification is.
No. Say, what does section 24 say?
24 says, my lord, of compensation, my lord.
How much?
That.
Some temporarily settled.
It's there.
এইখন নহয় এইখন লেণ্ড ৰেভিনিউখন দিয়ক না লেণ্ড লেণ্ড লছ এইখন নহয় এই নীলা কিতাপ এখন আছে চাওক ডাঙৰ ইমান ডাঙৰ না নীলা কিতাপ সেইখন দিয়ক এখন পুৰণা নতুন এখন আছে দেখোন The total compensation payable for acquiring the ownership of land as per intermediary right, if any of any holding, shall be an amount equal to 50 times the full rate of annual land revenue.
Yes.
Now, 24 says this. How are you having this 1610 business?
23A has been inserted.
23A says what?
23A says, my lord, if any occupancy tenant who are in continuous possession of such land and whose names are recorded in the record of right as per section 55 of the act and whose land has been subsequently included in town irrespective of present usages of such land if desires to, because Lordship has seen, my lord, that there is a finding, my lord, in the speaking order that it was not a special cultivation land.
It's okay. Now,
So therefore, if desires to acquire the ownership rights, may at any time make such application in such manner as may be prescribed to the deputy commissioner and the compensation as per section 24 of the act. And on such application, the district commission.
understood. So state government shall levy such fee for conferring such ownership right
Yes,
to
so
the
this is in
occupancy tenant as may be notified from time to time.
Yes,
So this is done under 24A2.
yes, this is in addition.
So this is for townlands.
Townland, and therefore their land, this part and parcel of land is included in the townland. It is FS grant land. It was originally in the nature of grant land, and it was meant for special cultivation. Then it was found that, my lord, because Lordship will kindly appreciate why the sealing proceeding has started. Sealing proceeding has started because of the fact that, my lord, the entire land was classified as special cultivation. And on my lord, physical, my lord, inquiry, it was found that there is no special cultivation as such. So therefore, my lord, it was, my lord, pulled out from the sealing proceedings. It could not have been a part of the sealing proceedings. Nonetheless, my lord, this part and parcel of land was recorded as a khatiyan under the 1971 Act. So therefore, my lord, in order, since that they have acquired, my lord, they have purchased the plot of land as being a part of the khatiyan. So therefore, my lord, their names were recorded as occupancy tenants. And now for granting ownership, my lord, they will have to pay the premium. This is how, my lord, it is calculated. Therefore, now, in the bunch of instructions, my lord,
Why the amendment 23A was bought? You already have 23.
yes, but perhaps because of what has fallen from my lord, that for town lands, my lord, this 50% of the land revenue, 50 times of the land revenue, my lord.
At any
may
time
not
after the
sufficient.
commencement of this act by notification regulated the right title of any occupancy personally cultivating the land of the tenant. So this amount only the government will take. Not the owner will not get.
Listen, this is an addition. This 10%,
Uh.
10% will be in addition. Because under 24, which Lordship has just now seen the provision.
So if a person makes a payment, because the person has to make a payment of 10%.
If you go to the.
No. The person has to make a payment under 23A1 also. That amount will only go to 10 or 25,
Yes. That amount will go to.
which
the
is
original
the
contract.
compensation is equal to 50 times the full rate of annual revenue payable for the land.
Yes.
So that amount one has to pay.
Yes.
Isn't it?
Yes, madam, that is. Because Lordship will kindly see, my lord, 23A,
Uh.
the amendment, 23A1 and 2 also, my lord. State government shall levy
Understood. So 23A1
1,
refers to 24.
24, yes.
And 24 is the amount which, as per 25, will go to be payable to the owner. So the owner gets the same amount,
Same amount. And some that happened, yes.
but the state gets a huge
Huge
premium.
amount. That gets a huge amount because of, my lord, 23A2. A2, state government shall levy such fee. Because earlier it is compensation and this is fee. For conferring such to the, as may be notified from time to time.
Now, this is in respect to the 23A gives a very important distinction from 23. 23 says any occupancy tenant personally cultivating the land of his tenancy,
Yes.
desirous of acquiring the ownership rights of his landlord, may at any time make an application in writing to the Deputy Commissioner.
Yes.
And on such application being made and compensation as provided in 25 is determined and paid to the occupancy tenant,
Madam.
the Deputy Commissioner shall declare the occupancy to have become the owner. Now here he is personally cultivating the land of his tenancy, desirous of acquiring the ownership rights.
Yes, that is the condition precedent.
Understood?
Yes.
Now the question is subsequently,
Yes.
any occupancy tenant who is in continuous possession of such land
Yes.
and whose names are recorded in the record of rights of tenants as per section 55 of the Act and whose land has been subsequently included.
Included in town.
So that means prior to this 23A, lands which were included in the townlands were not covered under the Assam Temporarily Settled Area Tenancy Act. Or is it the case that the Assam Temporarily Settled Area Tenancy Act could not have been brought within the purview of the townlands? It seems to be that. That's the reasoning. Now, let us see the exceptions to this act. Now, have you amended? Yeah, therefore you see, here you see section 2 has been amended.
Section 2.
Has been amended. Therefore, you see, in the Principals Act, section 2 in F, after the words townland, the following words and punctuation shall be, except the lands by occupancy subsequently included. So therefore, F, where is the F? F? D, E, F?
Exception, people find the exception to section 2.
The Principal Act in section 2.
The act does
in
not apply to.
clause F. এখন পুরনো কিতাব সব। Where is F? Oh, F. Here, you see, therefore I said, lands included in townlands, F was outside the purview of temporary settlers. Now what has been brought in, subsequently included, is now being brought in the Act of Assam Temporarily Settled Area Tenancy Act. So therefore, if you were issuing a khatian at that point of time, how could you have issued a khatian in respect to a land which is within the townlands? So therefore, this amendment, the entire Amendment Act cannot be made applicable to the case of the petitioners here, because this was outside the purview.
Now, this 71 Act is predominantly a legislation for the protection of persons who are actually cultivating.
Cultivating.
Yes. Now,
Therefore, it was outside. So townlands, you could not have applied this act.
nonetheless, also, my lord, in one another view of the matter, this is having a prospective effect. Now, therefore, Lordship, for a moment.
No, that is not the issue. The issue is whether there could have been at a settlement in view of 23A not being there. A settlement could have been the ownership, conferment of ownership granted under 23. That is the issue.
Yes.
You have to get the point
Yes.
on that aspect. I'm not concerned with this. You see, if the Act of 1971 could not have been applied to townlands, and in the meantime, this land has been brought within the ambit of the townlands, till 23A comes in, does any person have a right to get a settlement, ownership? My question is that, which has a much bigger effect.
Because
So if I today say simply that, okay, this act would not apply in the case of the petitioner, then on what basis does the petitioner get ownership? Please tell me.
he gets ownership on the basis of continuous possession. Therefore, my lord, in order to give him a handle, a rider, this, my lord, the provisions of this act has been applied to. Because there is the only marked distinction between 23 and 23A is that, my lord, in 23, a person has to actually do the cultivation, but in 23A, the person may.
No. You 23A, you kindly see the last page of your bunch.
Yes. Who are
They
you?
amended section 2. See this. This is why I'm saying.
Yes.
In the Principal Act, in section 2, in clause F, after the words townland,
Yes.
the following, except the lands held by occupancy subsequently included in townlands and are in continuous possession irrespective of their present uses. So therefore,
How they are using the land? Yes.
therefore, this exclusion,
Yes.
which is otherwise applicable for townland,
Yes.
was watered down by this exception being brought in
Absolutely.
to
Absolutely.
section 2F.
Yes. Yes.
So therefore, 1971 Act was not at all applicable prior to there could not have been a ownership right
Yes.
in land, in any land, in any townlands, which were subsequently brought in,
Frequently brought in.
unless you bring in this amendment.
Therefore, my lord, that is why 23, because ownership rights would have been acquired because, my lord, under 23. And in 23, occupancy tenant personally cultivating. I am personally cultivating. There may be a situation that I am personally cultivating. I am the occupancy tenant. My name is recorded in the record of right, that is the khatian. And there may be a situation, my lord, that these lands, khatians, being a part of townlands.
No, we cannot exclude the new act. Yeah. But what can be done is, for your benefit, is either the government does on their own with 258,000, they're happy, they can do it by themselves. Or you give me the relation between Lahiri and Brigadier Lahiri. So that on the basis of that, I say that that was a sale of a patta land. And as such, you are entitled to back of the 2,28,000 and also the mutation.
Then, Lordship, with that,
That is the way out for you.
Correct.
Otherwise, the new act applies.
For a moment, my lord, for my satisfaction, my lord, if lordship sees, my lord, this bunch of documents, my lord, at page 49, serial of page 49, because admittedly, their names were recorded as Khatian holder. That is why. my-
Who?
In the Khatian, this petitioner's name, page 49, lordship.
No, they may be.
Yes.
Put as a Khatian holder. As if it was a sale by a Khatian holder to a Khatian holder. But actually, this could not have been done because the
Yes.
ownership was there. It was illegally done so.
Yes.
It was illegally brought within the ambit of the final statement,
Yes.
which was corrected in the year 2020. So therefore, we can very well deem that there was a proper sale being made by Brigadier Lahiri to your whoever it is. And as such, this, on the basis of the sale, you are to be given in the by issuance of a proper patta.
Yes.
So that I can do so. But I am again constrained to do so in a contempt proceeding. How do I exercise that right? Unless this clarity is being brought in.
Yes.
You just find out.
Lordship, will
Okay, you find out that aspect. We will take it up again. In the meantime, if the government
decides.
out of generosity does it with that 2,28,000 and all, they can very well do it.
Right.
Otherwise, they lose that 2,28,000.
Yes.
It will be a case of refund.
Okay.
But provided you again have
The
to,
link
that is
between-
again subject to you
Link provide.
bringing the link of Lahiri with this.
Lahiri.
Genealogy, basically, my lord, he will have to satisfy your lordship with the genealogy. That's all.
If you satisfy me with the genealogy,
Lordship.
I will hold it. That this was not a ceiling surplus land. It was a patta land which has been.
Indeed, Lordship, will do so.
Yes.
And what is this tenancy case?
Lordship, the tenancy case had arisen after the government's order, Your Lordship. since it
So you therefore filed an application seeking ownership under 23.
Lordship, we had filed an application before the deputy commissioner and also the circle officer, seeking that the land needs to be mutated in our name. Therefore, any necessary steps.
No, no,
will be
you
taken.
filed a tenancy case.
Lordship, we did not file. It was suo moto on the hands of the authorities, Your Lordship. There is a communication, if I may provide Your Lordship. Lordship, I have a marked copy. It has been cited. Lordship, this order dated 6/1/2021. If I may read it, Your Lordship. Yes.
But Mr. Counsel, do you have another problem?
What?
Problem arises is this. If this is a special cultivation land, which have been allowed to be retained, can there be a sale of the special cultivation land? That is another big issue. It is something like selling of a portion of a tea garden land. This is a FS grant land.
Lordship,
Mr. Counsel, I think better off you should advise your client to pay the 23 lakhs. Because of why I am saying so. It has reverted back as an FS grant land.
Right.
And if it is an FS grant land, it is a special cultivation land. And a special cultivation land cannot be given the status of a patta land because it is always remain as a special cultivation land. You see, if you see the Assam Fixation of Land Holdings Act 1956, as well as also the 56 rules, it says, more particularly Section 5 says, what are the things which can be retained? This originally belonged to a tea state, Bokhisto tea state. From that, certain portions could have been retained and certain portions could not. 224 bighas went out there, including your land. But this land could have been retained. This land could have been retained taking into account that this was used for house purpose. This is as per Rule 5. But it still has the flavor of a tea cultivation land. And if it is so, how can there be a transfer of a sale being made by anybody without the special permission of the government, which is again required, whatever may be, Deputy Commissioner's permission also, this was done in 83. So there was no problem with that. But the sale could have been made of a tea land without converting the tea land to any other land. That is another big issue. Think about it.
Indeed, Lordship. Will do. Lordship, however, the records in
Yes. I had missed that aspect of the matter. Lordship is.
Lordship, it
Yes.
also.
I was, I thought about it earlier, but I was not saying so. But at the end of the day, the moment I hold it, this, for your case, it is okay, no problem. But this will have further effect tomorrow when the journals report it and there is a transfer of a tea garden land into a patta land, which will have far-reaching consequences.
Understood, Lordship.
Because you see, tea garden lands, if you see, these are not only registered with the state as a tea land, it is marked with T. These are therefore said to be special cultivation. And if you see the order of 2020, it categorically mentions about it as a special. But also in the tea board of of India, it is also recorded out there as tea land. So you once you want to convert it, in fact, in many places in Guwahati, Assam, some of these people who are residing nearby the towns, some tea lands, like just for example in Dibrugarh or in some other places in Hunitpur and all, where nearby Tezpur, all these things, they were trying to do so. And there were all criminal cases also there, where the Mondals as well as the circle officers indulged in doing all this. Didn't it? Yes. So that is what. So I think you advise your client simply to pay that. And as of now, you are getting 2 bighas of land. Good, happy. 23 lakhs, 2 bighas is good enough. 2 lakhs you have already paid.
Lordship, 2 lakhs we have paid.
So
On
remaining
the
you have to
clinical.
pay and they will get it done. I think that is the best way out because this will have a lot of other repercussions.
Lordship will look into that. Lordship, however, to my understanding, since I'm relatively new, your Lordship, Lordship, what I was one element that has been also classified as Habari. Habari as in a homestead where a person resides. So, in having so, and also
Have you ever looked into a copy of a chitta? Of a copy of a chitta of a tea garden land?
I haven't had the opportunity.
Have a look.
Lordship.
It is always mentioned as special. It's a grant land.
Lordship.
These are grants being given by the year for 99 years now, next 30 years and so on. So these are grant lands only for special cultivation. Therefore, it is said to be grant. It is in FS grant. Just for example, in this particular area, what is now this area is what? That Zoo Road area is what now? Earlier it was another under these Dombrain people. That used to be also one of that is Sunsalitis. Now this was again acquired. A lot of land were acquired during the 1976 on the basis of the ceiling. And therefore pattas have been given. So there are a lot of people who have pattas. And certain lands were retained. So those retains were retained and these were sold by the people. These originally belonged to this Dombrain. DW Dombrain and all these Dombrain, these 3 Dombrains it belonged. So therefore you have this sale which are being made. You see. But on all these lands, when in the tea garden land, it is always mentioned in the Chitta that what is the classification. There may be Hali also. Some maybe in some areas which is in for the purpose of Bebohai. It's a business land that is also there inside the tea land. So that may be there because there might be a market held. So that at that point of time, it is being classified as that. Playground for that Hali land. Bum land. All these things are already mentioned in this.
But it retains the overall character of special cultivation. That is what
But
matters.
overall, it is special cultivation. So that is it. I think best you advise.
We will also recollect, my lord, that Red Cross office, my lord, where it is situated in the Sanmari area.
Yeah.
That also falls within the ambit of that original, my lord, tea cultivation.
Yes, yes. No, that is that
Totally
other
other
land.
dispute.
That is that not this land. Not the. I think it's the Sunsaligram. Sunsaligram. That's all the Sunsaligram.
Yes,
And it goes till Nunmati and all.
yes.
Go beyond that.
Till, my lord, that river bank.
Riverbank. So now these people are having some big complexes were being made.
Yeah.
That is also comes under the Sunsali belt. It's a huge belt. All this area, for starting from Junarangi Road and ending out there somewhere near the riverbank.
It's a
Huge area.
this part.
So that is Sunsali Grant and this is Bokhisto Grant. Chalo. Hearing remains inconclusive. So, Mr. R. Borpujari appearing on behalf of the respondents have placed before this court a set of instructions which are kept on record and marked with the letter Y. Full stop. Taking into account the instructions, a copy of which, have you given him a copy?
Yes, yes, I will write
A
down.
copy of which have also been provided to Mr. So-and-so, the learned counsel for the petitioner. The matter stands adjourned to be listed again on 30th
30th October.
30th of October 2025 at the top of the list, showing it as part third. You, I think, best you take this, then I keep it, pay the 22 lakhs or 20 lakhs or whatever maybe, because you see, there is another big problem. Why I don't want to enter there also, there is another thing. All along, what is being happening out here, 23A has been brought in. First of all, in town lands, there cannot be Assam temporarily settled here 1971 Act. However, you may see in many lands, more particularly, I say, see those areas in Ahumgaon and all this area. Ahumgaon where you have the DPS and all these areas. These areas, all this, or even the area in, you see this place, you must have seen that Gargia Toyota and all this, all these areas were village. And there, Assam, you have the Khatiyans being issued there. And there, a lot of people got ownership rights, applying 23. But later on, it came to light that it could not have been given because these have been included. And that is why the amendment has been made in bringing in 23A. Isn't it?
Yes, that is the reason. Because I need to only pay 50 times of the land area.
Ah.
It is such a bigger amount.
Ah.
And once I pay it, I get the ownership back.
No,
Immediately
but the state government is earning more
now.
at the cost of the owner. Owner is not getting. In fact, that the owner should challenge that 25 and say that they should get 50% of that. Obviously, the owner has to get.
Yes, my lord.
For motion item 12,
So
Yes, what is this? Where is Mr. Ardhor? Yes. Yes, Mr. Bora.
Lordship, a tender was floated at page 21 for supply of 52 inches subtle steel loom by the handloom on 21/9/2025. Thereafter, at page 27, some additional terms were included by the procuring entity. At page 29 is the experience criteria.
You have enclosed the entire document, tender document?
Yes, Lordship.
Okay.
This much I had, Lordship. This much I had, Lordship. I was.
No, there cannot be I had. When you are appearing for the tenderer, so the tenderer, when you are appearing for the tenderer, you know for whom you are. We deem that you are the tenderer.
Yes.
So the entire set of the document, tender document, have you enclosed it here?
Yes, Lordship.
Okay. Now what is it?
Because, Lordship, at page 26 and down.
Yes, Mr. Chaudhary.
Yes. At page 26.
Sorry,
Lordship.
my lord.
You are saying yesterday they have in fact made it in such a manner that there is no competition.
Yes,
Yes, what is that?
yes. First, my lord will kindly come to page number 29.
29, yes.
Roman 4. Bidder must have an experience in government supply of at least 50% amount of the total bid value during the last 3 financial years ending 31st of March. That is 22, 23, 23, 24, 24 and 25. That is important. Experience will be considered for supply of machineries and equipments to any government department. Now, my lord, this requirement has been substituted following a so-called pre-bid meeting
At page 36.
at page number 36. How can the essential requirements be dispensed with? Now, please come to page 36 towards the bottom two sentence, my lord. All concerns raised by the suppliers were discussed in detail. After thorough deliberation, the committee unanimously recommended the following amendments to the tender document. Now, kindly see, the earlier clause is on the left-hand side. Now, what has been substituted is on the right-hand side. Now, I'm reading from the fourth line. Experience will be considered for supply of relevant goods,
So earlier it was machineries and equipment.
equipments. Now, my lord, Assam government has framed a statute. In the statute, they have said that you will not take any step which will have the effect of relaxing the terms. Rather, you should insist on conditions which will promote competition. Please, I've annexed that act, my lord. If your lordship should kindly come to page 47. The statute is called at page 46. And this is Assam Assam Public Procurement Act 2017. Now, if your lordship should kindly come to page 47, I have given the relevant extract, my lord. Participation of bidder towards the bottom. Procuring entities shall not establish any requirement aimed at limiting participation of bidder in the procurement process that discriminates against among bidders or against any category thereof, except when authorized or required to do so by this act or the rules guidelines made thereunder by the provisions of any other law for the time being in force. Now, to effectuate the purposes of the act, rules have been framed, my lord, and the rule is at page number 44. Relevant portion 12.1 Roman 3. The procuring entity and all officers of the employees of the procuring entity, whether involved in procurement process or otherwise, or other persons involved directly or indirectly in any way procurement process, shall maintain an unimpeachable standard of integrity both inside and outside their office as prescribed under subsection 1 and 2 of section 11 of the so-and-so, etc., etc., or the relevant conduct rule by whatever name called or any other law for the.
So,
Now please come to 3.
Mr. Chaudhary,
Yes.
you had the qualification of
I have all the
supplying-
qualification.
Huh?
I have all the qualification.
Then what is your problem?
No, my problem is, my lord, by incorporating this clause, the scope of competition has been reduced, my lord, because now anybody will come without even having experience. What is this relevant field, my lord?
Scope of competition have been reduced means means it is better for you?
No, my lord. Question is the item to be supplied is machinery. So naturally, person, prospective bidder, he must have experience in supplying machinery. Now machinery has been substituted to the relevant goods. That means any Tom, Dick and Harry will come. The very probity in the tender process itself is questionable now, my lord. That means they would like to favor somebody who do not have the required experience.
On suggestion of bidder.
How can on this, my lord, pre-bid meetings are not meant to change the requirements. Pre-bid meeting are held, my lord, for other purposes. Clarification, if there is any clarification, how to deal with particular clause. Now a bidder who doesn't have the experience of supplying the machineries, he will also be eligible now. This is relevant goods is a very vague term, my lord. Earlier it was machinery and equipments.
Now they will have relevant means
Goods.
relevant to the item category.
Experience will be considered for supply of relevant goods to the government department as specified during the last 3 years.
So that will be specific to 52-inch RS fly shuttle loom with 6 posts. This is the type of category they are going now.
No, Milo. The work is of supply of equipments. Who can do it? One who is having experience in the field.
No, Mr. Chaudhary. Now they will be limiting. In fact, they are limiting the competition and saying that relevant means you cannot say that tomorrow you are giving some other engines or anything. We are not concerned. It has to be specific to the item category for which the tender has been issued.
No, Milord, that is not permissible under the rules. Please come to page 44 for a moment, Milord. 44, Milord. 44, 12, 1, 3. Not to use or include unnecessarily restrictive or tailored specifications, terms of reference, statement of work, limitation or terms and conditions that may discourage wide competition or unnecessarily exclude certain categories of prospective bidders from participation. This is the purport of the rule. Now by saying,
No, this rule says you should increase the competition.
yes,
Means
you should not
more
retard
people-
competition, it should further competition.
You should have more people participating. This is what it says.
No, Milord. What is, as per the original tender, one is to have the experience of supplying the equipments which we possess. Now, Milord, supposing a tender says, I would like to, the department would like to procure equipment. Now, what should be the natural corollary? That he must have the experience of supplying or such equipments.
So that is what they are saying, that relevant goods will be specific to those goods for which they are seeking. Isn't that the case?
No, let my learned friends make his argument. I'll reply, my lord. I do not know what he's trying to say. It's very easy to say that is the word. What is that is the point? Then why the original clause? No, my lord. Question is
Earlier, a person who has supplied a train engine would have been could have been very well taken into consideration because it would have been a machinery or an equipment.
no, my lord.
But
Let
now
us
they are
try to
restricting
understand the
only-
problem from the what is the item, and let us come to that requirement, my lord, at page 21. And let my learned friend explain how this is going to further the competition. Item category.
No, it will not further, it will lessen the competition. Isn't it? Mr. Bhatt? Isn't it? It will lessen the competition.
That is what is not permissible, my lord.
Therefore, you want that many other people should participate.
Of course, not me, my lord. It's not my perspective which is important. What is important is from the perspective of the employer, buyer. Buyer should ensure that in this competition, more and more people should participate who are having experience. Now, by doing the impugned exercise, my lord, they are limiting it. How can they do that? That is not the purpose of the rules. Look, for example, my lord, what is required? 52-inch RS fly shuttle steel loom with 6 posts made of metal. Now, this is a specific thing. So the prospective bidder must have experience of supplying this. Now, the initial conditions clearly says that you must have experience of doing this.
No, initial condition says that if you supply even what you call the any loom also would also do. Any other machines connected with handloom is enough.
Let my learned friend explain how it is going to further the competition, then I'll give my reply.
Okay.
My understanding is, my lord, very simple. Now they're trying to limit the competition, which according to us, it cannot be done.
My lord will take up page number 27. This is the NIT one. Page number 27. Notice inviting by the Directorate of Handloom and Textile for 52-inch RS fly shuttle steel looms. My lord, this is the first time that we have come up with steel looms. Earlier, it was all wooden looms, my lord. So this is the first time, my lord, it is, the main frame will be in steel, the rest will be on woods, my lord. My lord, as of we know, my lord, this room, my lord, this has got a very, my lord, deep connection with the Assam heritage and everything, my lord. Weaving, my lord, it's a part of life for the people of Assam. My lord. In villages, it's, my lord, almost sacred.
Those considerations, Mr. Dhar, does not melt my heart.
I'm just coming, my lord. I'm
You
just coming.
come directly to the point.
I'm coming straight there, my lord. I'm coming
Yeah.
straight there, my lord.
What happens in Assam, how these looms have
Now-
importance, we are not bothered.
Initially, we came out to the tender.
Uh,
My senior was very correct in page number 25, my lord. Clause 4, page number 29, clause 4. That experience part, that experience will be considered for supply of machinery and equipments to any government departments undertaking. So initially, my lord, that was the thing, my lord. We say equipments and machineries and equipments, my lord. My lord. So that was our, my lord, early condition.
But what do you say at page 24, clause 4, past experience?
Yes, my lord. Similar category products to any central
For
government. Yes,
50% of the
that
bid
is there.
quantity, at least in at least one of the 3 financial years before the.
Similar category means, my lord, supply of goods. Supply of goods. If whoever it is, my lord, the bidder, he must have an experience of supplying looms. Particular, my lord, this type of looms. Now, my lord, coming here to this, page number 29, my lord has seen our initial condition was machinery and equipments. Then, my lord, the previous page, page 28. My lord, there are the, in terms and conditions, there was the pre-bid meeting. And why was this pre-bid meeting, my lord? It is categorical, my lord, we have indicated in the tender document for what this pre-bid meeting was, my lord, called for.
Where?
Page number 28. My lord, that is the terms of the tender, pre-bid meeting. A pre-bid meeting shall be convened on the date specified in the tender document for the purpose of discussing the tender process. During the meeting, bidders may seek clarification and purpose and propose potential amendments, my lord. My lord, amendments or additions. Additions at this meeting is mandatory for all bidders to ensure that their queries are duly addressed. No request for change or clarification shall be entertained after the pre-bid meeting under any circumstances. So, my lord, in pre-bid meeting, I have that document, my lord, including the writ petitioner, 8 bidders they participated. I'm just placing it. He also, my lord, but he did not raise anything, my lord. But the other bidders, they raised one particular issue, my lord. They say one particular, my lord, bidder said, in Hindi he said, हम जानते हैं कि हाथी सबसे बलवान है, लेकिन you cannot let him climb a tree. My lord, exactly that is the thing, my lord.
What?
A person may be, my lord, financially stable, everything, but my lord, he may have, my lord, supplied, my lord, medical equipments, steam engines, my lord, marine equipments, everything and anything under the sun. But my lord, if he hasn't done supply of looms, production of looms, my lord, that's an altogether very separate, different aspect, my lord. Very different thing, my lord. And why initially I said, my lord, this is very sacred for the state of Assam. This loom is connected to the, my lord, culture and heritage of the state. My lord.
I also know, Mr. Dhar, you
No,
need
my-
not say anything.
No,
I know with a steam engine, you cannot have a loom.
No.
Yeah.
So, my lord, now, when said that, my lord, that is why, my lord, when these objections came in, proposals came in for amendment, my lord.
So now you are specifying that it
yes.
will be relevant
Only
to relevant to the product which is sought to be
Yes.
procured.
Yes, it will be easier for us even, my lord, because we know, because these are, my lord, for beneficiaries, we'll give it for free.
This, my lord, these are government schemes, my lord. This will go to the, my lord, waivers. This, women waivers, my lord, in the villages, my lord. Tomorrow it doesn't, my lord, work properly. Who will take the, my lord? There are issues, my lord. That's why, my lord, now, yes, when we say that, my lord, initially when we came up with the NIT, that clause, my lord, yes. We used it, but later on, my lord, we amended it. When it came to understand, yes. The proposal came from the bidders, that's correct. Was those who have already dealt with such equipment earlier, they will be only able to, my lord, do it. Anybody, my lord, he may be, my lord, a very big supplier of equipments, my lord, agricultural equipments, whatever, my lord. But he cannot, my lord, if he hasn't done, my lord, supply of or manufacturing of looms, he must have some idea. That is the thing, my lord. And my lord, there is no but petitioner can, if he has supplied it, my lord, he can always bid. We are not stopping anybody. Where this can be arbitrary, my lord.
So all these 8 now can be, all these 8, because to be present in the pre-bid meeting is compulsory.
Compulsory.
So therefore, all these 8
Yes,
can bid now.
bid now. They have participated, my lord.
Okay, let them bid.
My
We'll
lord,
see.
my
You file your affidavit.
my lord.
Lordship is permitting everybody to bid. Yes.
No, not everybody to bid. One who
person-
is qualified to bid.
No, no.
Those
As
are
per
qualified.
what
Present
it
in the
is,
pre-bid
as of
meeting.
now,
Those
as
were
per the,
present in the pre-bid meeting, my lord.
no. One who has supplied relevant goods. Now, whether it is relevant as per your perspective or his perspective, that I'll decide later. Let everybody submit their bids.
My lord, can I make this submission, my lord? I'm not holding the brief of anybody else. Let I also submit my bid.
No,
Let somebody else, others also submit their bid. They will consider it, but whatever they do, that will be subject to further orders to be passed by your lordship.
No. The question is whether you are, have you supplied relevant forms of equipments or not?
That I have, my lord.
So then there is no problem with
If
you.
that is the issue, yes, supplying is not an issue.
No, then you don't have a problem with that.
Huh.
We are on the bigger issue.
Yes, lordship will clarify that I have no problem.
Yes, relevant goods.
Because here it says, his specific contention is the relevant means relevant to what is the item sought to be
No, my lord,
procured.
what I have understood from the impugned proceeding emanating from the pre-bid meeting is, my lord, those who manufacture loom, they alone can supply. That was the query.
No, the experience will be considered for supply of relevant goods to any so and so during the last 3 years. Where is the question of manufacture?
If supply is the issue, I have no issue, my lord.
Mr.
Yes, I'm clear.
Mr. Dhor,
My lord.
Mr. Dhor, kindly come to the recommendation. Here is bidders must have experience in government supply of at least 50% of the total bid value during the last 3
Yes,
years.
that we have.
The experience will be considered for supply of relevant goods to any. It doesn't say anything about
Yes,
manufacture.
but that we are agreeable. We have no issue with that. But if what
Mr.
we were given to understand is something else.
No. Kindly see page 37.
My lord, I'm just trying to correlate with the page number. Earlier,
Earlier is page 24.
24.
Kindly see
No, on the
faster.
left-hand side,
bidder
not
so
there.
and so
No, my lord, on the left-hand
should
side
have
in 37 it is there.
supplied same or similar category products for 50% of the bid quantity in at least one of the 3 financial years before the bid opening date to so and so. Copies of supply order so and so to be submitted along with bid in so and so. Where is the
My lord, page 37, both are there, my lord. Left-hand side is the earlier one, right-hand side is the,
no, there is no concept of manufacture.
yes.
I also didn't find.
I also don't see so.
Fine, fine.
So this will continue. They'll have to, anybody who has the year of the relevant, I'll put your thing. The relevant goods means relevant to the goods which is sought to be procured.
Procured, yes.
Yes, they have supplied in last 3 years.
Or-
It was managed.
Will issue notice?
Yes.
Issue notice making it returnable on, when can you file your affidavit? I'm not saying it.
No, man, I will find my thing.
When? You obviously you will like.
2 weeks.
Huh?
Within 2 weeks.
Okay. Issue notice making it returnable on 3rd of November 2025. Mr. Ardhot accepts notice on behalf of the respondent numbers 1 to 5. Extra copies of the writ petition be served upon him during the course of the day. We'll have it on 7th, huh? You file your affidavit by 3rd, he will file his reply by 6th, we'll take it up on 7th. The petitioner herein have challenged the amendment to clause 2 Roman 4 of the additional terms and conditions of the additional or 2 Roman 4 of the additional terms and conditions as sought to be made by the minutes of the procurement committee meeting held on, what is the date?
Millard.
Date held on 24th of September 2025. It is relevant to take note of that the respondent authority have through the GM through the GM portal have initiated a tender process for the purpose of supply of 5,000 supply of 52-inch 52-inch R.S. ply subtle steel lube with 6 posts made of metal steel bracket 3 mm bracket close with base plate and ACC of a total quantity of 5,000. At clause 4 of the bid document, the past performance of the bidder or its OEM have been duly mentioned. It stipulates that the bidder or its OEM should have supplied same or similar category products for 50% of the bid quantity, in at least one of the last 3 financial years before the bid opening date to any central/state government organization/PSU. It is relevant to take note of that in addition to the terms and conditions mentioned in the bid document, there is an additional terms and conditions in the said additional terms and conditions at clause number under the caption terms and conditions, there is a mention of pre-bid meeting, which stipulates that a pre-bid meeting shall be convened on the date specified in the tender document for the purpose of discussing the tender clauses and it was mandatory on the part of all the bidders to ensure that their queries are, that they attend. Full stop. It is further stipulated that during the meeting, bidders may seek clarification and propose potential amendments or additions. Clause Roman 4, Clause 2 Roman 4 is of relevance is inasmuch as it is the modification of this clause, the present writ petition has been filed. Under such circumstances, Clause 2 Roman 4 is reproduced hereunder, page 29. It is seen that in terms with the bid document, the pre-bid meeting was held on 24/9/2025, wherein as many as 8 bidders, proposed bidders, participated, including the petitioner. Pursuant to the discussions, an amendment was sought to be made, was recommended to be made by the tender committee to clause 2 Roman 4. The recommendations made for the amendment to clause 2 Roman 4 being relevant is reproduced hereunder. Next one. The petitioner herein is aggrieved by this recommendation made to amend the original clause 2 Roman 4 on the ground that it would limit the competition which ought not to have been done, taking into account the provisions of the Assam Procurement Act 2017 and Rule 12(1) Roman 3 of the Assam Public Procurement Rules 2020. It is the submission of Mr. K. N. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, that by making the modification, the respondent authorities are trying to limit the competition which could not have been made. The senior counsel submitted that it is the statutory mandate of the Assam Public Procurement Act 2017 and the rules framed therein under that there should be encouragement in more participation. Per contra, Mr. Ardhor, the learned counsel appearing on behalf of the respondent authority, submitted that the tender in question have been issued in respect to a particular item that is 52 inches RS and as such, the clause 2 Roman 4 as it stood earlier was ambiguous, and for the purpose of more clarity, the clause 2 Roman 4 it originally stood was amended, thereby incorporating that the experience would be considered for supply of relevant goods which would have relevance to the item which is sought to be procured. This court have heard the learned counsels appearing on behalf of the parties. The petitioners have prayed before this court that the amended that the recommendations so made to amend clause 2 Roman 4 by in the minutes of the procurement meeting dated 24/9/2025 is required to be stayed pending disposal of the writ petition. This court had given an anxious consideration as to whether any interim order is required. It is very pertinent at this stage that this court made a specific query upon Mr. K. N. Chaudhary, the learned senior counsel, as to whether the petitioner in the present case has the experience of supply of the item which is sought to be procured by the tendering process. The learned senior counsel submits that the petitioner has the experience of supply.
No, I didn't say that. I didn't say that I have an experience of supplying. They say relevant goods. So anybody who has supplied can come into the fray. Now we say we are dealing in amongst others, other machineries.
You are not dealing with looms.
No, I am not. I have no experience of supplying looms. That's not my case, my lord. That's why we are challenging this. We say the original clause was that you must have the experience of dealing with machineries and equipments. That we have.
Or you don't have with limb.
No, I know loom supply I have not made, my lord.
This court had heard the learned counsels appearing on behalf of the parties. Taking into account that the respondent authorities are the authors of the document, authors of the tender, or the respondent authority are the best persons to know, to set the eligibility conditions. And what they intend to do by way of the amendment to clause 2 Roman 4 is seeking experience from of persons having supplied similar goods or similar goods, which is also the mandate of clause 4 of the bid document. It is the opinion of the court that no interference at this stage is required. The respondents shall bring on record their stand by filing their affidavits on or before the next.
But our participation will participate, Lordship will eventually consider what happens, my lord.
You participate?
Yes.
They will consider whether it is relevant or not. Why am not they dealing with that? I am saying about whether it is relevant or not, that is the subject matter.
What ends with relevant? But what is relevant, my lord? That is not there.
So that we will consider.
Yes. Therefore, my lord, it will be open for us to participate. At least that observation lordships can make, my lord. Subject to further orders of the.
No, I am not saying that. I am saying that you can very well participate. You can very well participate. That is your cause. Whether if they reject, that is another cause of action they may have. Now, whether it is relevant or not, that is another issue.
Eventually, lordship will take a call at the time of hearing. So therefore, my lord, lordship has to keep the cause of action alive. Lordship will also observe, we may participate subject to outcome of the case. Keep the cause of action alive.
No. That I am not. You participate. Go ahead. But the question is whether they reject or not. The moment I do that, subject to outcome, they have stalled. They can't go ahead. Wouldn't that amount to a state?
No, I'm not saying that, my lord. Lordship, no.
The moment you are just
No,
for
if
example,
your lordship stays the tender process, nothing would move. Now, if your lordship says, now let us presume in this way, my lord, lordship permits us to participate. We participate.
Okay.
That doesn't mean that they will consider, give us the order. They will consider in their own right. That eventually lordship will take a call at the time of hearing. That, my lord, equities are balanced then. Supposing, my lord, we succeed in establishing that this amendment was uncalled for then my case will be considered. If your lordship upholds that, no.
And at a line, at a line. The non-granting of the interim order shall not preclude the petitioner from participation.
Yes.
If relevant goods, they have. exclusive
Exactly.
welcome.
That is the call which your lordship will take
Yes,
eventually.
my lord. We are not stopping anybody.
Yes, yes. Deeply obliged.
Wait, busy lordship. My lord, matter partners, my lord, no instance of site visit certificate, my lord. Despite of, my lord, page 80, my lord, here first approach the
Site visit,
my lord. Thereafter, my lord, page 81, my lord.
why you are not giving?
Lordship, we have already issued the site visit certificate to him, Lordship. And not only to him, the other participants also, Lordship, this is the certificate which we have already issued, Lordship. On 6th of October, on the day on which he has produced that site visit certificate, that he has annexed the photograph also.
Then, what was the last date of submission?
7.
Then,
On 6th, we have issued the site visit certificate to him. Moreover, here is a call recording, in which we have called him on the 6th of October at 1:13 PM, we have called him, and at 6:10 we have called him, and 6:11 he called us back. He did
6:11.
that. Yeah, really. This is the call. Yes, certificate. We have called him for collecting the certificate. On 6th of October.
so you had a talk with him, 4 minutes, 18 seconds.
Yes, Lordship. Now, after that, he had called us.
No, he has called you at 6:11.
Yes.
It's a different thing, but at 13:13,
Yes.
there is 1:13.
Yes, we have called.
Outgoing call, 4 minutes, 18 seconds.
Yes.
Means you must have talked to him.
Yes, sir. We have told him that to collect the certificate, that site visit certificate.
Petitioner submitted
Because
his
in-
bid, my lord, but without the service certificate, my lord. He had submitted his bid, my lord. He had submitted his bid, my lord, but without that certificate, my lord. The site visit certificate.
Has the tender process been over?
No, my lord.
It's running. It's continuing.
Not yet open, my lord.
Not
Technical bit has been open.
open?
Technical bit has been open. As far as my telephoning instructions, which I have received, telephonic bit has been open. Lordship.
And you have rejected him,
No, not yet,
not rejected.
not yet.
So then take into consideration this, as you have already issued the site visit certificate. Take into consideration that.
Yes.
Right.
Matter-
Here I know.
We dispose it of
My
then.
lord, my lord.
Heard Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner. And Mr. R. M. Das, the learned counsel who appears on behalf of the respondents numbers 1, 2, and 3. The petitioner herein has approached this court challenging the actions on the part of the respondent authorities, more particularly the respondent number 3, in not issuing the site visit certificate to the petitioner. For which the petitioner had to submit his bid
My lord.
without the said site visit certificate. So it is relevant, take note of that the respondent authorities had issued a notice had issued a invitation for bid for construction of embankment on R/B of River Mora Des Pagladia from Makrapara to Barpit. One of the conditions mentioned in the said notice invitation for bid
Page 29.
clause
7, my lord, page 29.
7
32 page.
No, no.
is that the bidder at its own responsibility and risk have to visit and examine the site of work and its surroundings and obtain all information that may be necessary for preparing the bid and entering into a contract for construction of the work. The cost of visiting the site shall be at the bidder's own expense.
Right.
It is the case of the petitioner that the petitioner visited the site on
6:10, my lord.
610. That is in
Six-
page 82.
6:10 at 9:43 am, my lord. Page 82, my lord.
Last page, Lordship.
visited the site prior to 24/9/2025 and sought for a site visit certificate from the respondent number 3 on 24/9/2025. Subsequent thereto, a petitioner gave a reminder on 6/10/2025. However, the said site visit certificate having not been issued, the petitioner participated in the said bid without the said site visit certificate. It is under such circumstances, the petitioner apprehending that his bid would be rejected on account of non-submission of the site visit certificate, has approached this court seeking an appropriate redirection and order upon the respondent number 3 to issue the site visit certificate with verification against the work of construction of embankment on RB of River Mora Pagaldia from Makrapara to Borpit under Nolbari Water Resource Division at serial number 27 of the NIT dated 26/8/2025.
Right.
Full stop. Upon the requisition being taken up for motion, Mr. R.M. Das, the learned counsel appearing on behalf of the petitioner, respondents, submitted that on 6/10/2025 itself, the site visit certificate was issued to the petitioner along with 2 others. And the petitioner was also telephonically informed about the said aspect of the matter. In that regard, he has placed before this court the 3 site visit certificates issued to the petitioner as well as 2 others, which are collectively kept on record and marked with the letters X. Full stop. To substantiate that the respondent number 3 had also telephonically informed the petitioner, a call record details have also been placed before this court, which is kept on record and marked with the letter Y. Full stop. This court, upon hearing the learned counsels appearing on behalf of the parties, had inquired with Mr. R.M. Das, the learned counsel appearing on behalf of the respondents, as to whether the technical bid have been finalized it has been duly informed that the technical bid have not yet been finalized. Full stop. Considering the above, considering that the site visit certificate have been duly issued in favor of the petitioner on 6/10/2025, which is kept on record and marked with the letter X, it is the opinion of this court that the respondent authorities is required to take into account the said site visit certificate dated 6/10/2025 issued by the respondent number 3 in favor of the petitioner while considering the technical bid of the petitioner. Full stop. Accordingly, the instant writ petition stands disposed of with the following observations. Number 1, the writ petition, the respondent number 3, respondent authorities, and more particularly, the respondent authorities jointly and severely are directed to take into account the site visit certificate that you must be having a copy, na? Take that. Respondent number 3 will have a copy of the site visit certificate. So that you take it, because again, asking him to give it will be again another problem out there. So jointly and severely are directed to take into account that the petitioner has been issued a site visit certificate on 6/10/2025 and on the basis of the same, the petitioner's technical bid be evaluated. Full stop. Number 2, this court observes that full stop. The above direction so passed is only in respect to the site visit certificate. Issue only in respect to issuance and consideration of the site visit certificate. And this court have otherwise not mentioned anything about the eligibility of the petitioner in respect to the tender process.
Right.
A copy of this order, number 3, Mr. R.M. Das, the learned counsel appearing on behalf of the respondents, is directed to telephonically instruct the respondents about the instant order so passed. And full stop. The registry is also registering. The courtmaster of this court is also directed to provide a copy of this order during the course of the day to Mr. Anandas.
14.
15. I think 15 is also same.
Same.
Yes, ma'am. It is a different.
Then how many persons you have issued?
Okay. Same.
3. Give it to me, those 3. And phone call?
16.
Phone call the same logic.
Same. Phone call, make a photocopy of that Y, a photocopy kori aru eta Y kori. Aru yar naam kita pele koi.
Yes, logic.
Now,
Only the name is different.
The work would be different.
Work and, yes, sir, only the work name is different.
Otherwise, it's all 6/10.
Yes, ma'am. 16 to?
16, they have filed 3 cases, 13, 15 and 16. 16 is something different. Logic. They
Okay,
have-
let's take up 16. So 15 is disposed of in this manner.
Right.
14 disposed,
In
16
16,
disposed,
16 also what they have done.
16.
16, they have sent the email on 6th October 12:49 AM asking for this site visit certificate. And on 6th October 12:49 AM, the site visit, which he has been asked to visit the site because he has not visited the site, Lordship. That is why engineer has asked him to, asked him to visit the site, and one person has been deputed, one officer has been deputed. That he has mentioned, Lordship. That is page 80, Lordship. He has mentioned that one officer, namely so-and-so, has been deputed for joint site visit on 6th.
my lord, if you lordship,
Then early morning. he has
yes, my
made
lord,
that-
that mail, my lord, which was delivered on 7th October. at 12:39 PM, my lord. 7th
Huh?
October, kindly see the above portion, my lord, the mail, my lord, received, delivered,
Where?
page 79, my lord. From Buxar W division,
This was sent at 12:39 daytime.
yes,
12:39, yes. We have sent it.
7th October, my lord. 7th October, it was sent,
No, he sent on 6th at night
Yes,
from his home. Then
on 6th.
on
the
6th
daytime,
at 12:39 PM, you
PM,
say, please find and attach herewith so and so.
That letter.
So you send this letter
that
on 6th.
NXR 80.
not on 6th, that is 7th.
No, on 7th?
Yes, my lord, 7th October.
7th October you sent.
Yes. 6th night,
Giving dated on 6th.
6 midnight he has sent. So 7th October, we have sent him this one.
And that was the last
He
date.
has not visited the site, Lordship.
Where is your photograph?
No, my lord, because, my lord, kindly,
Where is your photograph?
on 7th, that was the last date, my lord.
I'm asking you, where is your photograph?
He did not visit, my lord.
Why?
Because kindly see that letter.
No, without visiting, how do you ask for this?
No, my lord, that letter, kindly see.
No,
that-
no, no, Mr. Counsel, tell me, first of all, most particularly in those two matters also I saw it, you seek for a site visit certificate without visiting. 24/9/2025, you sought for a site visit certificate without visiting. You visited on 6/10/2025.
My lord.
That is the photograph which is
Yes,
being given.
yes.
Here you did not visit.
Kindly that certificate which was issued on, kindly come to the letter dated 6/10/2025. That was attached, my lord.
Yes, then
It was received by the petitioner on 7, my lord. That is the last
whatever
date.
may be, but the fact remains that why you did not go earlier.
Yes, my lord. That is the lack on the part. Yes, yes. I am admitting.
No,
My lord,
This
here, my
I
lord,
can't help.
they have, my lord, the communicated the letter.
No, 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 no. You did not visit. You cannot ask for that. You did not. You see, the person representative of any person is not required.
Right.
You need to visit as per clause 7.
Yes.
You should have visited, given the photograph and gone there. You did not go.
My lord, may I submit, my lord? Here, my lord, this letter was received on 12:39 PM, my lord. Even if, my
Mr.
lord,
Counsel,
my lord.
tender was issued on 25/8/2025.
Yes.
Does it take 2 months or 1.5 months for you to go and visit?
No, no.
Then you are not entitled to. Heard Mr. S. Hawk, the learned counsel, appears on behalf of the petitioner, and Mr. R.M. Das, who appears on behalf of the respondent numbers 1, 2, and 3. The petitioner herein is aggrieved by the non-issuance of the site visit certificate, for which the petitioner had to submit his bid without the site visit certificate.
My lord, in this case, my lord, he did not, in this case, my lord, in this package, my lord, he did not submit his bid, my lord.
You did not submit the bid.
My lord.
Then what remains?
My lord,
I can't help you this way or that way. It is aggrieved by the non-issuance of the site visit certificate.
he could not submit his bid.
Mr. Hawk, you have to be a bit careful. You don't keep on filing petitions like this.
My lord.
This petition, you should have told your client, don't file this type of matters.
Right.
Other two, I have allowed you.
Right.
But this type of cases, I should not. Like this, that
Well,
day,
yes,
another.
I
you are
really
also-
appreciate that.
You are also the standing counsel of this person. Well, along with Jiar Pasa, you are this is another Mohammed
No,
Amin.
he is new, my lord.
Huh?
He is new, my lord.
He is new. You are also making him. How many contracts here there? You file so many matters. The petitioner herein is aggrieved by the non-issuance of the site visit certificate, for which the petitioner could not submit his bid, and as such has filed the present petition. It is relevant to take note of that the respondent authorities have issued an invitation for bid for various contract works, including the construction of new embankment on both banks of river Ohumara and Anglisiga,
Anglisiga.
Anglisiga, along with protection work at different reaches. One of the conditions stipulated in the notice inviting tender at clause 7
Yes,
is pertaining to site visit.
my lord.
The said clause being relevant is reproduced hereinunder. It is 7.1. Page 30. From a perusal of the above clause, it reveals that the bidder at his own responsibility and risk has to visit and examine the site of works and its surroundings and obtain all information that may be necessary for preparing the bid and entering into a contract for construction of the work. The cost of visiting the site shall be at the bidder's own expense. In addition to that, it is also relevant to mention that in terms with clause for Roman 1, capital Roman 1, K, there is a requirement of submission of a site visit verification report issued by the executive engineer along with the technical bid. In the instant case, though the notice inviting tender was issued as on 16/9/2025, isn't it?
Yes, my lord.
16/9/2025. But on 26/8/2025,
Mm. It, 16/9.
and it was published on 16/9/2025. The petitioner did not take steps for visiting the site and instead requested for a site visit certificate by the communication dated
4/10/20.
4/10/2025. Under such circumstances, the petitioner was issued, was intimate, under such circumstances, the petitioner was not issued the site visit certificate. It is further relevant to take note of that the petitioner also did not submit his bid. Consequently, this court does not find the instant writ petition find any good grounds for entertaining the instant writ petition, for which the writ petition stands dismissed.
Item 14.
হৈ গ'ল না?
14.
সেইটো কিমান নম্বৰ আছে? 13, 15, 16. 14. Again, site visit.
Yes, my lord.
Huh?
Yes, my lord.
What happened here?
Here, my lord, the petitioner has visited the site, my lord.
When?
Accordingly, assistant executive engineer has also recommended, my lord, but the executive engineer did not, my lord.
You
Kindly come to
visited the site on 25/6,
Yes, my lord.
25/7.
25.
Then,
Kindly come to page 170, my lord.
huh?
170, my lord. Last page, my lord. 170.
And when you visited the site, you asked for the site verification certificate on 24/7.
24/7 earlier, my lord. Thereafter, my lord, he had visited, my lord. And
And
thereafter,
then
my lord,
when did you ask?
my lord, it was actually 24/9, my lord. 24/7, my lord.
Huh?
24/7. Page, my lord.
No, Mr. You visited with whom?
Visited with the officer of the assistant executive engineer, my lord.
With reference, I have the honor to inform you that as per your instructions by letter, demand concerned officials from my office had visited the office site along with the concerned bidder of all package requested by him under Muktamanti so and so for the other site visit were found in the hands I request you kindly. This was done. What is the date? 25/7
Yes, my lord.
by the assistant executive engineer.
Yes.
Then
Therefore, my lord, he had recommended his name, my lord. 170, page 170, my lord.
one,
170.
that I know. Then
Yes, my lord. Therefore, no certificate has been issued, my lord. No certificate was issued, my lord.
in spite of that.
Yes, my lord.
And then
And my petitioner had submitted his bid, my lord, without that site visit certificate. my lord.
bid rejected.
Not yet rejected, not yet.
was 28/7.
No, that is not open, my lord, because my lord,
Regarding the status, can it be at tomorrow, man? Today I contact the executive engineer, whichever meeting, you will find all the instruction by the.
Now, if this is a document which have been issued, if this page 170 is true, and then it has not been issued, then I will interfere with if any technical bid is inter.
Not-
Yes.
He has submitted the bid without this particular certificate.
So then you have to, I'll pass a similar order like this,
And
which I passed for RM Das.
tomorrow for motion.
Tomorrow, list this matter tomorrow for motions.
smile. I'm deeply.
On which state and Mr. P. Gogoi, the learned counsel appearing on behalf of the deputy, sending out the bill, soliciting instruction as to whether the technical bid has been finalized.
Public.
For admission, item 17.
Yes, what
Well-
are we doing?
My lord, yesterday they have filed affidavit of opposition. my lord. Exponent has filed affidavit of opposition yesterday. Who?
Who is appearing here? Mr. P.
Mr.
Gogoi, what
Gogoi.
happened? Have they filed affidavit?
They have filed affidavit yesterday. They have
Then?
filed. So we have to file reply, my lord.
You want to file reply?
Reply, my lord. So
Mr. K. Gogoi, your matter. Oh, that RV. I understand that.
the
100%.
the change of name, my lord. The change of-
The thing of
The-
it.
That is the same stand by taken by them in the affidavit also, my lord.
Mr. S. Sharma submits that the affidavit in opposition has been filed on behalf of the respondents and a reply would like to be filed. Also taking into account the above, the
File reply
how much time?
by 22nd, by next opening day, I think. I can file on opening day, 22nd.
Like to file a reply, would like to file a reply to the state activity. Heard Mr. S. Sharma, the learning counsel appearing on behalf of the petitioner who submits that the petitioner would like to file a reply to the affidavit in opposition filed by the respondents. Is the matter again on 30/10/2025. In the meantime, the reply be filed on or before 28/10.
30th. Can it be a bit earlier? Can it be a bit earlier, but
30.
30.
I'm giving you 1 week's time. 10 days time.
10.
For orders, item 3.
Worship, as per our last order, we have filed a amended court certificate.
What is this matter for?
Regarding the Guwahati High Court, salary law.
Why this has come?
So last time Lordship had asked us why then ordered it in 19/6/2025 to implement the other states.
Ah.
On the last occasion we did so, Lordship had allowed the implement and Lordship had fixed the matter today. Choose the implement.
I fixed the 1610.
Okay.
So you are appearing, all of you? Assam, you are there, you are Arunachal Pradesh and you are for Tripura, Mizoram. You are for High Court and another state, Nagaland?
Nagaland Lordship.
Their names have been shown, huh?
Lordship.
Okay. Anyway, your participation is there now. as your names have been shown, you are now aware. Now, this is the matter pertaining to, which I may explain to you. Have you given copies to of the writ
Lordship,
petition?
not yet, Lordship, did not issue notice on the last date, Lordship.
Huh?
That I could not serve copies to them, Lordship. I'll serve it to them today, Lordship.
Okay, you'll be given copy. But anyway, the copy is one thing, but you give a certified copy of that order which I passed.
Lordship.
Now I'm told that Mr. Gogoi, there is a committee formed.
Yes.
With Justice Nair and Justice Midhi, along with all officials from all the governments. All the secretaries of the governments have been appointed out there. Now, here it is only for the purpose of, otherwise the matter would have been already disposed of. Only thing is remaining out here is to just look into it, what is the report being submitted. So it is at the hands of the Chief Justice who has to look into. Anyway, we today make it that Mr. P. Gogoi, the learned additional advocate general, Assam, comma, Ms. P. Bhattacharya, the learned additional advocate general, Mizoram. You are? That I know, you are? Additional senior government advocate, Arunachal Pradesh, and Ms. So-and-so. You are also additional advocate general? Additional advocate general Nagaland. And Ms. So-and-so. You are not a High Court counsel?
No.
EJ Mohanto is not there, you don't have. Okay. Needy. Appears pursuant to notice have been issued. Extra copies of the writ petition be served upon the learned counsel representing the state of Nagaland, state of Mizoram, and state of Arunachal Pradesh within 3 days, along with a copy of the order, certified copy of, along with a copy of the order dated 19/6/2025. Was to place this matter on, otherwise the matter was fixed on
Lordship fixed on 18/12.
2025.
Lordship's matter will come up on the original date of 18/12.
No, 18/12.
For hearing item
With
four.
respect to those associations, did I issue notice or not?
No, Lord.
Okay, association issue notice upon the newly impeded respondent numbers. Did you file your
I filed them.
on issue notice
They would
upon
be
the newly impeded respondent number?
7 and 8, Lord. 12 and 13, Lordship.
Huh?
12 and 13.
Respondent numbers 12 and 13, steps be taken by way of speed post as well as to the registry of this court by speed post
Lord.
within 2-3 weeks.
Lord.
List on
For hearing item four.
Mr. Mahmood, your item is item number 10.
Yeah.
Somebody mentioned it without taking your concurrence.
No, I was informed, but I have said that at due time you say, because my parties are insisting me to get the case disposed of.
But the
At due
problem
time,
is,
but-
there's a big problem out here, taking into account that the BTC councils have changed. They have not handed over the file to the newly appointed councils. So that is the problem where I have fixed it on, I fixed it on 17, no, on 18/11.
It is a covert case, my lord. It is a covert case.
Over case for what?
There are some judgments of our high court. The similar judgment I want.
Understood, you can, but without they having a
Then
file.
very short date may kindly be given, because since last 1 year I am deprived of my severance law.
You're
Illegally,
deprived of what?
no inquiry report was furnished. No complaint was furnished to me, who filed complaint against me. So in such a manner that my fair price shop license was cancelled.
Your?
Fair price shop license.
You said no.
That's the
You
problem.
wanted to do it before vacation.
Yes.
I remember. Okay. We'll have it on 4th. This item number 10, we'll have it on 4th. We get your instructions.
She can, he can take also copy, Xerox copy from me also.
You give a copy to her. Sure, copy of the petition.
You can Xerox free law. Yes, I will give. On
Instead of 17, 18, I have made it 4th.
411, 411.
Item 4 for hearing, Pathak.
Yes.
My lord, this matter was heard by your lordship. This matter relates to the termination of an ambulance driver. On the, without inquiry, on the basis of some allegations which were not proved or established in the inquiry before the Labour Court. And as per the last order, lordship wanted us to place some precedence on the question of loss of confidence.
What was the matter? I forgot. What did I say last time? I said I was in your favor. In your favor, but again, I have also asked her to look into the aspect of loss.
Loss of confidence. Now, my lord, so for
And
loss of confidence.
you say on the last occasion that if the termination is illegal, then a question of loss of confidence does not arise. You say. But
Coupled with
anyways,
one judgment which I've come across, which has laid down certain tests to be applied. Now, 2001, volume 9, SCC 609.
the old judgment.
Now, here, the question is, what must be pleaded and proved to invoke the aforesaid principle is that the work number 1, that is to be pleaded and proved by the employer. 1, the workman is holding a position of trust and confidence. Number 2, by abusing such position, he commits act which results in forfeiting the same. And number 3, to continue him in service would be embarrassing and inconvenient to the employer or would be detrimental to the discipline or security of the establishment. Now, my lord, here it is a case, it is not the pleaded case of the management that they had lost confidence. It is the labor code which has brought in that. It is nowhere in the written statement, evidence by the management before the labor court that there is a loss of confidence. It is labor code.
No, wait. First, tell me what was that issue? What did you say on the last day? No, I was deciding something. I said that this was not true for some other good reason.
What happened?
Last time I said that something was not done by them.
Yes. They did not have any material to hold that I was guilty. Before the labor court, they rely on a letter of the petrol pump owner. But the same.
No. I asked her a particular question that there was one letter which was written and there is a subsequent letter written. What is the inquiry made that the subsequent letter was brought or was made up? Was there any materials to that?
No.
You see, initially a person comes up and says, look here, this person was using all this. When you issued notice to him or something, you transferred him. Or
Yes.
transferred. Then a letter was written by that particular owner that look here, this was not done by me, but it was said that it was him. In fact, it was somebody else. But you took up opinion that this appears to be made up subsequently at his behest. What is the basis of that? You did not have it, and neither there is anything on record to show anything. So therefore, not to trust the second document, you have no business. That was the reason what I say.
Last day, you also pointed out that Why should I rely on one document which is in my favor and not rely on the other document which is in his favor, which was absolving him from any liability? So your lordship wanted me to find out if I can sustain the termination on the basis of loss of confidence. Can you show me something that you guess you lost confidence and you terminated him because domestic inquiry was not held? And on the previous dates, your lordship, I was able to satisfy that without domestic inquiry, if the matter is referred to labor court, the matter can be heard and decided. So now, your lordship, I have come across a document also, which also was another ground why I lost confidence in the employee. If your lordship may permit, can I produce the document before the court? It is an email, your lordship.
Why?
Your lordship, because we terminated him in the month of June 2021. And this email from the management to the petitioner and from the petitioner to us, the two emails, your lordship, it was in the month of March. And in that email, on 25th of March, he wrote an email to the management that yes, the vehicle, the ambulance which he was driving, it met with an accident. And I have changed the front mirror at my own cost and I've repaired it. 5 days later, we gave an email, a reply to that email to the petitioner saying that no, we have conducted our investigation and you have taken the front glass from another vehicle and changed it. And that was not done on your cost. So this was one more reason why we lost confidence, your lordship. And
No, madam, wait. Do I look like a judge sitting in the labor court? Then how do I look
your
into
lordship,
that?
last year you wanted me to prove why I lost
No.
confidence.
I never said that. I said, can you argue on the point of loss of confidence? Because if it is a loss of confidence, there might be a case of compensation and may not be a case of reinstatement.
Yes, your lordship.
That is what I allowed. Not on the basis of allowing you to produce documents here. I am not a labor court.
Just for the knowledge of this honorable court.
No,
the
knowledge,
other
that is,
factors-
you see, that is something, it is something like that, where I can't see those things.
Your lordship wanted me to know before the termination whether we conducted any inquiry, whether we had some material on the basis of which we.
That is also not
terminated him.
there. Madam, the problem lies there. There is a particular document issued by one person. You place reliance on that document. And subsequently, you did not take into the next document and terminated subsequent to that document. So the question is, why you did not take into consideration or did you have any inquiry? There is no evidence to the effect. So as there is no evidence, this has to be set aside. Now the question is, can there be a case of reinstatement? Now, a reinstatement, you can very well say that I have lost the confidence. For that, I asked you that you come up with something as to whether you can maintain your case of no reinstatement and going for some form of a compensation instead of reinstatement. That is why I asked you to look into something.
Yes, your lordship, I found judgments in which it has. been-
Fantastic. We will have it after recess.
But that again, it was consent for 7 days, but it has been done for 1 month. Can it be earlier be posted? Item 2.
Item number 2 on 1811.
Yes, can it be earlier, my lord? Since settlement of a particular fishery.
I've signed that order, no? Why didn't you come earlier? Anyway, I fixed it on a Tuesday.
18. Oblige.
Yes.
Your lordship, I have a few judgments on the point of loss of confidence, your lordship. But before going into that, your lordship, I would like to make a submission that the best course of action now, according to me, your lordship, would be to remand the case back to the labor court. Because your lordship, there, no doubt even we failed to bring the owner of the petrol pump on record. But there was same failure on their part also. Both the parties failed to adduce them as as an evidence. They were not examined, they were not cross-examined, Your Lordship. And the whole case is because of a letter issued by them and then multiple letters issued by them, the owner of the petrol pump. So, Your Lordship, if the owner is brought into record and if evidence can be taken from him as to arrive at the root cause of which letter he actually relies upon, Your Lordship, because the petitioner does.
Is such a course of action permissible? I'm exercising 226. 226. I'm exercising the jurisdiction of a certiorari jurisdiction. Have you looked into the judgment of the Supreme Court in the case of Temporal Research versus Vikartan Das? We looked into it. Yes, read paragraph 48.
48.
48 on.
Before we close this matter, we would like to observe something important in the aforesaid context. Two cardinal principles of law governing exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to issue of writ of certiorari. The first cardinal principle of law that governs the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue of a writ of certiorari, is that in granting such a writ, High Court does not exercise the power of the appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. The writ of certiorari can be issued if an error of law is apparent on the face of the record. A writ of certiorari, being a high prerogative writ, should not be issued on mere asking. The second principle of exercise of extraordinary jurisdiction under Article 226 is that in a given case, even if some action or order challenged in the writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction thereunder, can refuse to upset it with a view to doing substantial justice between the parties. Article 226 grants an extraordinary remedy, which is essentially discretionary, although founded on legal injury. It is perfectly open for the writ court exercising this flexible power to pass such orders as public interest dictates and equity project. The legal formulations cannot be enforced divorced from the realities of the fact situation of the case. While administering law, it is to be tempered with equity, and if the equitable situation demands, after setting right in legal formulations, not to take to the logical end, the High Court would be failing in its duty if it does not notice equitable consideration and mold the final order in exercise of its extraordinary jurisdiction. Any other approach would render the High Court a normal court of appeal, which is this not.
So, under such circumstance, can I remand it?
Your Lordship, here I am not praying for reconsidering the tribunal's order or making any changes to the order, original order. I'm just asking your honor to remand it back so that the evidence can be laid again, because various evidences have not been laid, Your Lordship. Your Lordship, even the petitioner in this case has not come with clean hands. If in the letter, if you can say the exact name of people who were involved, even if he's not involved, just to assume without admitting, Your Lordship, if he is not involved, if you can name the exact people, then he was aware about this illegal act, but he did not report it to the management, which is again a violation of the whistleblower policy, Your Lordship. And there are judgments which says that, Your Lordship, termination can be made on the basis of suspicion, because when there is suspicion, there is loss of confidence. And on the basis of that, termination can be made and reinstatement cannot be ordered. There are various judgments, Your Lordship. So my humble prayer would be to remand it back so that the owner can be brought on record, examined, cross-examined, and then the labor court can decide which of his various letters is to be taken into account, Your Lordship. Your Lordship, the first judgment is Kanhaiya Agarwal, but that is a similar finding which my learned colleague has already pointed about the three essentials which requires to be proved.
Which one is this?
Kanhaiya Agarwal,
Kanhaiya, I have it.
Your
You are
Lordship,
relying on Kanhaiya?
just to show the three aspects. Your Lordship, paragraph 12. Which shows that the three principles which must be proved, that the person was in possession of trust, he has abused his position of trust, and to continue to him to stay in service would be detrimental to the establishment. Your Lordship, the next
550. Not this one, the next one. SSC citation. Yeah, 19.
This judgment goes against you.
Your lordship, I have 5 judgments, your lordship. This is the first judgment. I know the basis, but your lordship, just to show the 3 principles which requires to be proved, I have produced this judgment, your lordship. Can I just point out the other judgments and then I would like to draw an inference? Your lordship, this is the second judgment. Francis Klein and Company, Private Limited versus the Workmen. Your lordship, may please see the last 2 paragraphs of this judgment, your lordship. The last page. In our view, which reads from in our view. Lordship, this is Air India Corporation Bombay versus B.A. Rebolo, AIR 1972 SC 1343. Your lordship, may please come to para 15 and 16 of this judgment. In this, it has been said that even on the mere ground of suspicion, there can be loss of confidence and the employee can be terminated.
You see, shouldn't there be a pleading on your part that there has been loss? That's
Before the tribunal. No. That hearing was not specifically taken.
secondly, has to be objective satisfaction, not subjective satisfaction. Subjective satisfaction is a satisfaction by which a person, individual may have satisfaction on a particular facts. Objective satisfaction is based on parameters by which this is the particular parameter which are laid down, and on laid down parameters whether he fits it. The Supreme Court says has to be the objective satisfaction and not the subjective satisfaction. If it is not the subjective satisfaction, it is the objective satisfaction. Then you have to plead and prove the requirement for all these things, that you have lost the confidence. He was having a position of trust. One. Secondly, it would be not proper on the part of the court to reinstate him taking into account that if he is given in that particular post, it would be an embarrassment to to them. There's no pleading to the defendant. So under such circumstances, how do I interfere on that aspect?
Lordship, my submission would be that since the entire case revolves around the letters from one single owner, why not bring the owner on record, test him, examine, cross-examine him, and then arrive at a just decision, Your Lordship? Because since he has been terminated, even though the pleading was not taken, Your Lordship, I admit there was a lapse, but confidence has been lost, and then the establishment will never be willing to reinstate him. The establishment will never be willing to reinstate him, Your Lordship. Even if reinstated, they'll conduct an inquiry and then they'll find ways to remove him because they do not have confidence in the employer, Your Lordship. So why not bring the owner of this petrol pump on record, Your Lordship?
Can you tell me whether these two letters, exhibit 5 and 6, you received? it? These are the letters dated 10/4/2021 and 18/6/2021. Because you terminated him in May 2021.
June 2021, 15 June 21.
Your lordship was exhibited by the workmen.
So for this letter dated 24th of March 21, exhibit 5, it is their exhibit also as exhibit D. They have 24/3/21 letter, which is exhibit annex, exhibit D. It is exhibit their document, exhibit D, annexure 5. They have exhibited it.
The lordship, we have exhibited, here says exhibit D, the letter dated 24/3/21. This is to show that the submission I have been making before your lordship as well, that he knew the names of the people who were involved, which meant he was aware about me.
But the fact is, these documents, these three documents have been admitted by your management, which have not been admitted by the labor court, saying that this person have not been proved. But if you see the reply, that is in exhibit F. This is very relevant, exhibit F. Finally come down to last part, one paragraph of the first page. The management has reviewed the letter dated so and so and issued proposed notice along with transfer to so and so for payment. Management has not found any satisfactory reply in hand. They received letters from Joint Doctor stating that there have been demand. This is the letter which they have got from Louis XII. Then another letter has been written on 15th of June, on 18th of June, the next page.
That is after termination.
What do you mean? That is also written. And then you admit that this letter has been written.
Yes, sir.
And then you have written a letter even to Louis XII Service that if you continue to write such type of letters, we are going to initiate legal action against you. Isn't?
Yes, sir.
So if that be so, are these two letters are not admitted by you
Admit, sir.
in the contents of exhibit F, which the learned labor court have duly taken into consideration? Then the learned labor court could not have held that these two documents were not proved.
Lordship, this were admitted, that's why.
The learned labor court's order has to go. There's
Lordship,
nothing to prove it. The fact remains, now you are asking this to be sent back. On one hand, you are saying that kindly don't keep on writing letters to me. I will initiate action against you. And you want now to prove that particular person.
No, Lordship, because we have terminated on the basis of his letter. Your Lordship, if you may please come to exhibit D. The letter 24/3/2024, the first clarification letter which was issued the next date after the show cause notice. Here your Lordship will see Lohit, that person, he has written, the owner of the petrol pump, he has written, today we received a letter from Joyanta Kumar Datta stating that he had been lifting fuel from our depot for his own 108 vehicle. Your Lordship, he has no 108 vehicle. It is only the management's vehicle, Your Lordship. Even if he is relying upon this,
Whatever may be, it has been mentioned that he is not involved.
subsequent letter, yes, Your
No,
Lordship.
in that letter itself.
And that letter also says that he has named 4 other persons who are involved.
Other persons are involved is a different aspect.
But the owner of the petrol pump got to know about the other persons through him only, Your Lordship.
Enough.
And my lord, just one
What do you
judgment,
want?
when there is a,
May go against you.
no, my lord, just for a moment,
What judgment?
that when there is an illegal termination, the course of action is reinstatement with full back wages. However, the back wages can be reduced if the workman is gainfully employed. Now, here is a case, I'm giving the judgment, I'm giving the judgment.
What does it say?
I'm reading, my lord.
No, don't read. Tell me.
My lord, it says number 1, the propositions which can be culled out from the aforementioned judgments are, in case of wrongful termination of service, reinstatement with continuity of service and back wages is the normal rule. That is, my lord, 2013 10 SCC 324. Now, number 38. Ordinarily, the employee or workman whose service are terminated and who is desirous of getting back wages is required to either plead or at least make statement before the adjudicating authority or the court for first instance that he or she was not gainfully employed or was employed on a lesser wages. If the employer wants to avoid payment of full back wages, then it has to plead and also lead cogent evidence to prove that the employee workman was gainfully employed and was getting wages equal to the wages he or she was drawing prior to the termination of service. Now, here is a case in the evidence, the workman has stated that since his termination, he is not gainfully employed. And there is no material from the management to show that he was gainfully employed or receiving wages. In that view of the matter, my lord, if your lordship holds the termination to be illegal, then judgment is paragraph 38, my lord.
Where is your statement that you are not working gainfully?
My lord, it has come in the evidence of the workman.
No, in the petition.
No, in the labor court, my lord.
Here,
In the labor court, it was.
here,
Here
there is different.
No.
There is different. From there only till that point of time, till the labor court's order, I can give it to you. But why this? Here you have not mentioned anything.
But in the pleadings before the labor court,
That is okay then, but here you have not mentioned a single word.
he was not gainfully employed. That is why reinstatement with continuity and service and back wages, my lord.
Understood, but here you have not mentioned anything.
Here in the writ petition, it is not mentioned.
Then,
But in the labor court, it is nobody's case.
so we will consider as on 15th, the date of the award. You have not raised that issue. Why should we give you do back wages when there is not a single statement made by you that you are not good?
That statement was made before the labor court
Oh.
and was, evidence was,
Then go to the labor court. I'll remind it, let you go to labor court. Want to go to the labor court?
and no, my lord. What I am submitting before a lordship is that from the date of my termination, I was not gainfully employed. It is only when there is,
Whether you were gainfully employed, whether you are now gainfully employed, that is another aspect. Why should this, without a single statement being given, why
It
should
is-
this court
it's
say?
not even the case of the management also, my lord, that I
Why
am not.
will they say? Because when you are not pleading that,
It was pleaded before the labor court, my lord.
that is labor court. We are not in labor court.
And this is this proceeding is after the challenging the award, my lord.
So what?
The
I'll
record
set
of the,
aside the order, that's all. Set aside the award.
so
Set aside the award and directly in statement, that's all. Like, heard Mr. Chakravarti, the learned counsel hearing. What's your name?
Hey, Biani.
And so, here's on behalf of the respondent number 2. Mr. M. Setia, here's for the respondent number 1. The present petition has been filed challenging the award dated 19/1/2023 passed in reference case number 1 of 2022, whereby the award was passed in favor of the respondent number 2 and against the petitioner. The legality of the said award is the subject matter of challenge in the present proceeding. And as such, it is in the opinion of this subject matter of challenge in the present proceedings. To appreciate the same, this court finds it relevant to take note of the brief facts which led to the filing of the petition. The petitioner herein was admittedly appointed in the services of the respondent number 2 on 17/6/2009. On 23/3/2021, a notice was issued to the petitioner seeking explanation within 48 hours. On 23/3/2021, the respondent, the head HR of the respondent number 2 had issued a notice to the petitioner alleging inter alia that a notice was received from Indian Oil Corporation Limited regarding payment of an outstanding amount of 1,07,745 for fuels lifted by the petitioner for 108 dumper service of April 2014. It was alleged that there was a serious lapse on the part of the petitioner, and such an action was not acceptable. Petitioner was asked to submit a written explanation within 48 hours of the receipt of the letter, failing which the respondent number 2 would take disciplinary action up to service separation. On the same day, the petitioner services were relocated from Sipsagar to Kakomari in the Golaghat district, and the petitioner was asked to report on or before 25/3/2021. Although the show cause notice did not make any reference, show cause notice dated 23/3/2021 made no reference to on the basis of which the allegations were leveled against the petition. But the materials on record revealed that it was done so on the basis of a communication issued by one Manoj Poddar, who was the proprietor of one Lohit Fuel Service. Which of a communication dated 15/10/2020 issued by one Manoj Poddar, who was the proprietor of Lohit Fuel Service. In the same letter, which have been exhibited before the learned labor court, by the respondent number 2, at Exhibit A, it transpired that the said Manoj Poddar alleged that an amount of rupees 1,00,000 7,745 was the outstanding amount payable for various against fuel given to 108 dumper service. It was also alleged that the said fuel was lifted by the respondent number two's program manager, namely one Saurabh Datta and the petitioner. And in spite of constant reminder to make payment, the said amount was not paid. And under such circumstances, requested the respondent number two to immediately release such payment. The petitioner thereupon submitted a reply stating inter alia that the petitioner was not involved. Along with his reply, he enclosed a letter enclosed a letter issued by the same Manoj Poddar, the proprietor of Louis Fuel Pump, which clarified that the petitioner was not involved in respect to the pending bills. This communication issued by Sri Manoj Poddar dated 24/3/2021, whereby the petitioner was given was wherein it was categorically clarified, wherein it was clarified that the petitioner had no role, was exhibited by the management, by the respondent number two before the Learned Labour Court as Exhibit D. It is pertinent herein to observe at this stage that in the same letter dated 24/3/2021, bracket Exhibit D, it was categorically mentioned that the petitioner was not involved in the said. The record further revealed that another communication was issued by Manoj Poddar to the respondent number two, dated 10/4/2021, which was exhibited as Exhibit 5 by the petitioner. Wherein also it was categorically mentioned that the petitioner had no role to play in respect to the pending bills. Be it as it may, on 15/6/2021, the respondent number 2 terminated the services of the petition with immediate effect. On the ground that the respondent number 2, management of the respondent number 2 found that the petitioner was involved in fueling dumper by using company's name. Which was against the company's protocol and have violated the same by involving in illegal activity. It is relevant to observe that the same termination of the petition was done so without holding any domestic inquiry. Resultantly, an industrial dispute arose which led to the government of Assam issuing a notification dated 19/4/2022 making a reference under section 10, not reference under 10 or 10A. 10 of the Industrial Disputes Act 1947, for short, the Act of 1947. The terms of reference were as follows. Number 1, whether the management of GVK EMRI was justified in terminating the complainant. Question mark. Number 2, was due procedure followed in the form of disciplinary action before terminating the complainant sufficient? I sure these are the things.
My lord, this is what the award says. It is quoted in the award.
No. 19th of reference where whether the management of GVK EMRI was justified in terminating the complainant. The 2, was procedure followed in the form of disciplinary action before terminating the complainant sufficient? Number 3, what relief the workman is entitled to in case the retrenchment is termed as invalid? Pursuant to the reference being made to the Learned Labor Court, Guwahati, notices were issued to both the parties, to the petitioner and the respondent number 2, and both the parties duly submitted their pleadings. Here there is already this thing, loss of confidence is there, paragraph 11
Of
the written statement. In the written statement filed by the management. It was mentioned that the proceedings was initiated on the basis of the communication received dated 15/10/2020 from the Lloyd Fuel Service. It was mentioned that on the basis of upon such letter, investigation was carried out. And it was found that both the petitioner and his reporting manager, Mr. Saurabh Datta, were involved in such illegal act. Mr. Saurabh Datta, on being asked, resigned from service from his post as program manager Upper Assam. But as the petitioner did not resign, a show cause notice dated 23/3/2021 was issued. It was mentioned that on the very next day of the show cause notice issued by the management to the worker, to the petitioner, the owner of the Lloyd Fuel Service wrote a letter dated 24/3/2021 wherein it was mentioned that they had received a letter from Mr. Joyanta Kumar from the petitioner stating that he had been lifting fuel from Lloyd Fuel Service for his own 108 vehicle and had mentioned the names of Jotin Buragohai, Saurabh Datta, Saurabh Bora, and Pukil Buragohai were involved in the case. It was mentioned that the above written statement by the petitioner to the owner of Lloyd Fuel Service confirmed that the petitioner was aware about the lifting fuel illegal way and he was involved in it. It was further mentioned that after due investigation and dissatisfied with the reply of the workman and the owner of Lloyd Fuel Services, the petitioner's services were terminated, considering him as irresponsible and errant and demotivate the entire 108 team by illegal activity. At paragraph number 11 of the written statement, it was mentioned that GDK EMRA mentioned that the respondent number 2 operates Mrityunjay 108 ambulance service in the state of Assam. And it is an emergency healthcare service for the people of Assam. Violating the rules of standing order, the petitioner cheated with the respondent number 2, run 108 services, and his termination cannot be reconsidered as he was misusing the brand name of 108 service for his own interests. The petitioner also submitted his written statement wherein he stated about his appointment made on 17/6/2009, the issuance of the show cause notice, the reply submitted by the petitioner, as well as the termination of the petitioner. In addition to that, the petitioner also stated that he had made a complaint before the Labour Officer cum Conciliation Officer Sibsagar, Assam. But the conciliation proceedings failed. In addition, the relief which had been sought for by the petitioner was also mentioned about reinstatement in service with full back wages from the date of termination, plus all consequential benefits of his service, and rupees 2 lakh as cost of litigation. There was no reply filed by the petitioner against the written statement filed by the management or a rejoinder. No, there's a rejoinder. Negative. The workman, the petitioner, submitted a rejoinder to the written statement filed by the management, stating inter alia that the management had not conducted any domestic inquiry against the workman by issuing charge sheet and by appointing anyone as an inquiry officer. The management had also not served notice before terminating the service of the petitioner as required under law. On behalf of the plaintiff, on behalf of the management, evidence was adduced by one witness and 6 documents were exhibited as Exhibit A to Exhibit F. On behalf of the petitioner, he adduced himself as witness. and exhibited 6 documents also, which were exhibited as exhibit 1 to exhibit 6. Both the witnesses were duly cross-examined. The learned tribunal, by its judgment and order, passed an award on 19/1/2023, hereinafter referred to as the impugned award. Whereby it was opined that the petitioner was involved in committing criminal breach of trust of the management, causing a heavy financial loss and reputation. It was also mentioned that the management had lost total confidence upon the workman for his dishonesty and doubtful integrity. It was found that it was further opined by the learned labor court that when that the respondent number 2 were justified in terminating the workman from service, as the petitioner was found to be involved in such incident. Accordingly, the learned labor court opined that the petitioner is not entitled to get the relief of reinstatement in service, but the petitioner would be entitled to get PF contribution and other terminal benefits, if any. Being agreed, the present petition. Let me come back. I think it's a case for dismissal.
পিছত আহিব 5 মিনিট
Mr. S. Chakravarti, the learned counsel appearing on behalf of the petitioner. Submitted. The determination of the petitioner without holding a domestic inquiry thereby providing full opportunity to defend was contrary to the settled position of law. The learned counsel submitted that the impugned award therefore suffers from patent illegality, as this very aspect of the matter was not taken into consideration. The learned counsel for the petitioner further submitted that the entire action was based upon a communication dated 15/10/2020,
21.
20, no,
No,
15/10/2020. 20. And there is no materials placed as to what investigation was carried out, justifying that the petitioner was involved in the said incident, say in respect to the alleged misappropriation. That too when the author of the document dated 15/10/2020, subsequently on 24/3/2021, 10/4 and 10/4/2021, category mentioned that the petitioner was nowhere involved. The learned counsel submitted that if there was no domestic inquiry held prior to termination, the management of the respondent number 2 had the burden to satisfy on what basis or investigation the petitioner was found to have misappropriated. Nothing to that effect have been brought on record, as would be seen from the evidence, from the pleading, as well as from the evidence on record. The learned counsel for the petitioner further submitted that on one hand, the Learned Labor Court relied upon the communication dated 15/10/2020 issued the proprietor of Louis Fuel Services without the proprietor being adduced as a witness. But on the other hand, did not. But on the other hand, the Learned Labour Court insisted that the petitioner exhibits 4, 5, and 6 were not true on the ground that the proprietor of Louis Fuel Service did not appear as a witness. Referring to Exhibit F, which is a document exhibited by the management of the respondent number 2, the Learned Counsel submitted that in that very document, the management have duly admitted about the continuous communications issued by the proprietor of Louis Fuel Services to the effect that the petitioner was now involved. The said contents of the document, the contents of Exhibit F being not taken into consideration by the Learned Labour Court and thereby not relying upon Exhibit 4, 5, and 6 have rendered the impugned award perverse and requires interference. The Learned Counsel further submitted that the petitioner is not only entitled to reinstatement but entitled to full back wages. And in that regard has referred to a judgment of the Supreme Court in the case of Dipali Gundu Survasi versus Kranti Junior Adhyapak Mahavidyalaya (D.ED) and others reported in 2013 10 SCC 324. The instant petition was heard at length on 18/9/2025, on which date this court also asked both the parties to address on the issue as to whether the petitioner can be reinstated if the termination is held to be illegal on the aspect of loss of confidence. Mr. S. Chakravarti, the Learned Counsel appearing on behalf of the petitioner, submitted that the aspect pertaining to loss of confidence has not only to be pleaded but also proved on 3 aspects. Firstly, that the petitioner was holding a post of trust. Secondly,
The judgment 2001
that the petitioner had abused such position. Holding a position of trust and confidence. Secondly, petitioner has abused such position and he commits acts which results in forfeiting the same. And thirdly, to continue the petitioner in service would be resulting would be embarrassing and inconvenient to the employer or would be detrimental to the discipline or security of the establishment. The learned counsel for the learned counsel for the petitioner submitted that these three parameters are to be objectively satisfied. And not based upon subjective satisfaction of the management. In that regard, he has relied upon the judgment of the Supreme Court in the case of Kanhailal.
Kanhailal, 2001.
Kanhailal, Agarwal and others versus factory manager and others reported in 2001
9 SCC,
9 SEC 609.
paragraph 9.
Per contra, Ms. So-and-so, appearing on behalf of the respondents, number 2, submitted that the materials on record would show that on 15/10/2020, a communication was received by the management of the respondent number 2, stating inter alia that for a period since (16/12/2013) to 16/4/2014, the petitioner along with one Saurabh Datta were involved in lifting of the fuel to the 108 dumper service in the name of the petitioner, in the name of the respondent number 2, and they had not paid any amount. Upon coming to learn about the said aspect, internal investigations were carried out. And thereupon, after finding that that the petitioner, after finding that both Saurabh Datta and the petitioner were involved in such illegal acts, Mr. Saurabh Datta was asked to resign, which he did so. However, as the petitioner had not resigned, the petitioner was issued a show cause notice on 23/3/2021. The learned counsel further submitted on the next day, the proprietor of Luit Fuel Services issued a communication wherein it has been also admitted that the petitioner had filled up fuel in the 108 dumper service. Which vindicates the stand of the respondent number 2, that the petitioner was involved in illegal acts of misappropriation. The learned counsel further submitted that being not satisfied with the reply, further submitted that the petitioner in support of its reply, those submitted a reply on 24/3/2021 had stated nothing except bringing on record the except producing the document dated 24/3/2021 issued by the proprietor of Louis Well Services. It was found that the petitioner was duly involved. The learned counsel further submitted that the respondent number 2 is a non-profit organization and runs the GVK, EMRI, ambulance services. And the petitioner's position was a position of trust and confidence. And the petitioner having not and there being suspicion that and investigations carried out showed that the petitioner was duly involved. And as such, the petitioner was rightfully terminated. The learned counsel appearing on behalf of the petitioner further submitted, respondent number 2 further submitted that even assuming for argument's sake, although not admitting, that the termination was not proper, then also on the ground of loss of confidence, the petitioner cannot or not to be directed for reinstatement, as there was suspicion on the part on that, as on the basis of suspicion also, a person can be terminated from service, and in that regard referred to the judgment of the Supreme Court in the case of Air India Corporation Bombay versus VA Rebello and others, reported in 1972, 1 FCC 814. The learned counsel for the petitioner, respondent number 2, further submitted that there is not a single whisper in the writ petition before this court that the petitioner is not gainfully employed in any services. And as such, the question of even assuming, and as such, even assuming for argument's sake, this court interferes with the termination, the question of payment of back wages does not arise. I've heard the learned counsels appearing on behalf of the party and have also given my anxious consideration to the relevant, anxious consideration to the records. And I have also perused the materials on record, including the trial court records and records of the learned labor court. At the outset, it is relevant to observe that even without a domestic inquiry, a workman can be terminated from service. But however, in doing so, if an industrial dispute arises and the matter is placed before the labor court, it is placed before the tribunals under the Act of 1947, it is the burden upon the respondent, upon the management to prove that the termination was justified. This court have further taken note of the evidence on record have further taken note of the pleadings as well as the evidence on record. It is relevant to take note of that in terms with exhibit relevant to take note the entire dispute arose on account of the communication dated 15/10/2020, which is Exhibit A, issued by the proprietor of Louis Quail Services, wherein allegations were leveled against one Saurabh Datta and the petitioner. This court finds it very pertinent to take note of Exhibit F. Which is a document exhibited by the respondent number 2. Perusal of the said document revealed, contents of the said document, that is Exhibit F, revealed that the owner of Louis Quail Services have recanted its position as stated in the communication dated 15/10/2020 bracket Exhibit A. And in fact, the management of the respondent number 2 issued a letter to Louis Quail Services on 22/6/2001 21. 21, no? Have issued a letter to Louis Fuel Services to stop sending letters clarifying that the petitioner had no involvement in respect to the dispute, in respect to the alleged misappropriation. This court finds it also very pertinent that on one hand, the learned labor court had relied upon Exhibit A without the author of the said document being adduced, being brought on record, being adduced as evidence, witness. Rather insisted in the case of the petitioner that the author of that said document was required to be or to have been adduced as witness. It appears that had the author of the document dated of Exhibit A been adduced as witness, his evidence would have been in favor of the petitioner. And as such, the respondent, number 2, management of the, did not find it proper to adduce him as a witness. But on the other hand, on the basis of his allegations, which were subsequently recanted on 3 different occasions, as would be seen from Exhibit 4, 5, and 6, the Learned Labor Court came to an opinion that there was allegation of misappropriation, criminal breach of trust was proved against the petitioner. It may not be out of place again to remind this, may not be out of place to state that this is not a case where there has been already a domestic inquiry done, carried out. But this is a case wherein the respondent number 2 was required to prove that the petitioner was involved in an act of breach of trust or misappropriation. The evidence on behalf of the management only mentioned that they made certain internal investigation, but there is no mention whatsoever as to what investigation was carried out. In the opinion of this court, this is a case where there was no evidence against the petitioner. which was proved. But the London Labour Court failed to take into consideration the said. Under such circumstances, as there was no evidence, the findings so arrived at as regards the point of reference number 1 and 2, that the petitioner was involved in acts of criminal breach of trust. Is a finding based upon perverse reading of the evidence. Now let this court take into consideration as regards the third point of reference as to what relief or reliefs the petitioner herein is entitled to. The materials on record and the above discussions show that the respondent, number 2, have failed to prove that the petitioner was involved in a misconduct requiring termination from service. Under such circumstances, the termination has to be held to be bad in law. Now the question arises as to whether this is a fit case for reinstatement. At this stage, this court finds it pertinent to take note of the judgment of the Supreme Court in the case of Kanhaiyalal Agarwal Supra, wherein at paragraph number 12, paragraph 12
In SCC, it is paragraph number 9, my lord.
paragraph number 9. Paragraph number 9. It starts with substantial contention.
Yes.
9 and tested on these principles on the charges of here, whether there was any loss of privilege. Paragraph number 9 being relevant is reproduced here in under. Above quoted paragraph reveals the 3 parameters, the 3 principles which are required to be taken into account, pleaded and proved. When the code deals with the aspect pertaining to loss of confidence, the 3 principles the pleadings the pleadings of the management as well as the evidence so late do not show that the petitioner herein was holding a position of trust and confidence there is nothing mentioned on the basis of which there can be any objective satisfaction that the petitioner had abused his position and that it would be embarrassing and inconvenient to the respondent number 2 or would be detrimental to the discipline or security of the establishment. Considering the above, it is therefore the opinion of this court that the submission pertaining to loss of confidence and the findings so arrived at by the learned labor court pertaining in respect to loss of confidence cannot be sustained. The third, this court also finds it pertinent to observe, finds it relevant, take note of, that though the petitioner herein claims back wages, but there is not a single averment made in the petition that the petitioner is not gainfully employed. Considering the above, this court is of the opinion that the petitioner is not entitled to any back wages for the period after the award have been passed. Award dated, impugn award dated so and so have been passed. However, taking into account that the petitioner has mentioned that the petitioner was not gainfully employed in the written statement, and there was no substantive evidence being pleadings or evidence led during by the management of the respondent number 2 that the petitioner was not gainfully employed. It is the opinion of this court that the petitioner would be entitled to back wages with effect from 15/6/2021 till 19/10/2022. 19/1/2023.
3. Award is 23.
2023.
23. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The impugn award dated so and so, 19/1, passed in reference case number so and so, is set aside and quashed. Number 2, the petitioner is entitled to reinstatement with back wages, with full back wages, with effect from 15/6/2016/6, na?
15/6.
It was terminated on
15/6.
So you get from 16/6. 16/6/2021 till 19/1/2023. The petitioner would not be entitled to any back wages with effect from 19/21/2023 till date. Number 3, the petitioner be reinstated within 6 weeks 6 weeks. Within 1 month, 6 weeks. From the date a certified copy is served upon the respondent number 2. And the petitioner be reinstated and paid its back wages within a period of 6 weeks from the date a certified copy of this judgment is served upon the respondent number 2. Anything more?
Judgment per copy.
PCRB report.
So I'm just taking back the copy of the judgment, my lord.
What judgment?
The one which I was, which I had handed over to your lord.
Why?
Just to keep the citation in my record. I'll hand it over, my lord.
No, don't. You don't remember, don't remember. Madam, you tried. I also tried to help you. But you can't. Very bad. Something more should have. Seriously.
Item 5.
Employees Provident Fund Organization and Employees Fund Affiliate Authority in view of the order passed in the petitioner to file amended court file. Yes.
Respondent number 2, Lordship, is a bank. Respondent number 2 is a bank and covered under the Cooperative Societies Act. So due to some delayed payments from the year 2006 to 2011, damages and interest statutory were levied upon them. The respondents challenged the order before the appellate tribunal. The impugned order
What is this?
herein.
Whereas as per inspection report under section 88 of the Assam Cooperative Societies Act so and so, it appears that the Assam State Cooperative Agriculture and Rural Board had ceased working for a long period of time. You are ASCAD?
Yes, Lordship. It has been liquidated. We
Employees
have
Provident Fund Organization and another.
we have implemented the official liquidator.
It's for a long time. And declared objects are not likely to be cheap and economic, whereas as per the direction of the honorable court made it clear the pendency of the present petition. Will not be a bar for the raise that now therefore. Yes, now what is your case?
Lordship, the bank challenged the order of statutory imposition of statutory interest and damages upon them. There were some delayed payments from the year 2006 to
Some
2000.
appellate authority passed some order.
Yes, Lordship.
Now, why are you making
challenge-
the appellate authority a party?
Lordship,
Tell me.
that may be struck off, Lordship.
Huh? Who is the petitioner?
Employees Provident Fund Organization.
Employees Provident Fund
Organization.
Organization. What is that? It's the government of India organization.
Lordship, under an act, it has been
So this is under what act? Employees Provident Fund.
miscellaneous. EPFO and MP Act
1955 Act.
1952.
52 Act.
1952 Act.
Okay, so that act is a body is challenging an order passed by
The EPF Tribunal, Lordship. The
appellate tribunal.
Yes, the tribunal has reduced the damages by 40%, which was imposed upon the respondent.
So
number two
your
bank.
case should be against whom?
Actually, we are challenging the order,
Against Ascad Bank only.
Ascot Bank.
You cannot make the appellate tribunal a
Lordship.
party.
Lordship. Lordship,
It should be reprimanded.
Lordship.
Who has advised you? You were not there at that point of time. Were you there? Did you draft the petition? How are you, Madhurima Dutta?
A Chakraborty.
Huh?
A Chakraborty. A. Chakraborty, Lordship.
You are A. Chakraborty.
A. Chak-
Where is Madhurima Datta?
Uh, she is now a notary, so not appearing in this case.
Okay, so that is one. So employees appellate tribunal goes. Number two is Ascard.
Ascard.
Ascard is gone.
Yes, we have made the official liquidator party. We have implemented the official liquidator now.
You have made whom party?
Official liquidator, we have filed an implement petition and implemented the official liquidator.
So who is appearing for the joint register of cooperative society? Why you are making him by name?
Liquidator of official
liquidator
liquidator
is the by name.
by name, Lordship.
Where is it?
We have filed
Where when you get to
Implement
know
petition.
that he is the official liquidator?
Earlier, Lordship, for the bank, Mr. A.U. Ahmad used to appear, but now since official liquidator
Now
is
you want the money from them while
the
liquidating.
liquidator. From
Then
the
why you are not going there?
Lordship, what happened is that the tribunal has reduced the damages by 40%. The challenge in this writ petition is that the tribunal does not have the jurisdiction to waive or reduce the damages. The power lies only with the Central Board of Trustees.
Has notice been issued upon them? Newly implemented person
Yes, Lordship. Yes, Lordship.
who has received
In
the
service.
Huh?
Uh,
The order was implement only happened on 5/9.
1/9/2025, Lordship.
And when was the notice issued? Huh? When was the notice issued?
On the IA, Lordship.
In view
IA
of the order passed by residents to incorporate the new name of Iman, P.K. Roy, the learned, submits that the respondent has been liquidated so and so. Here you plead. When notice has been issued?
IA number 2251.
He has been made a party.
Yes, Lordship. Deemed
Not
service.
notice has not been issued.
Deemed service is deemed to be served.
How? How can it be deemed to be served? Somebody has to appear.
IA, my lord, kindly take up the IA
Where is
number
the Cooperative
2251.
Society, Corporation Department, anybody from corporation? Yes, he is there. You see, the joint register of cooperative society is the concerned liquidator. Now, while liquidating the Ascard Bank, certain amount will be paid to somebody will have certain claims. Now, their claims are being affected on account of an award being order being passed by the appellate tribunal. Now, this order has been challenged initially against Ascard Bank. But in the meantime, Ascard Bank has all been liquidated. Now, therefore, the official liquidator, somebody has to appear. Although this person has been made official liquidator, but the person is obviously, he cannot be bothered out there. It should have been taken because at the end of the day, this is being done under the some Cooperative Societies Act.
Yes.
So somebody has to appear. Who is going to appear? When after implement, where is the notice issued?
My lord, may
No
kindly
notice has
take up
been issued.
2251, IA number 2251.
I1 is for implement. Impleading is different. After impleading, where is the notice?
On the
Where is
in the
Mr. P.K.
WBC,
Roy?
Lordship. In the he is
He's still busy in court number 1.
Lordship.
Court number 1 is still sitting.
I think so, Lordship. I don't know.
That's it. But without issuing notice, it cannot happen. You accept notice?
But on the earlier occasion, we have not received.
No, they'll give you a copy of the order. It is seen from the records that by an order dated 5/9/2025, respondent number 3 have been newly impleaded. However, no notice has been issued. Mr. G. Bordloy, who is the standing counsel of the Corporation Department, accepts notice on behalf of the respondent number 3, who is the official liquidator appointed by the Register of Cooperative Society in respect to the respondent number 2. Full stop. Extra copy of the writ petition be served upon him during the course of the day. List this matter on 8th of December, 9th of December 2025. The respondent number 3 is given the liberty to file their affidavit in response on or before 24th of November. And the petitioner, if so advised, to be at liberty to file replies with.
Lordship, one extra day may be given for service of copy, Lordship. We will
What?
serve tomorrow. I don't have any extra copy. I'll have to Xerox it, and my copy is, means notes have been made. I'll prepare one extra copy to serve it.
Here also you have made notes, the judge also has made so much.
I'll have to prepare a separate
Hmm.
copy.
It's all red and blue and green and what. Okay. Tomorrow.
Tomorrow.
Take on.
Most obliged, Lordship. Most,
Tomorrow she will serve.
most obliged, Lordship.
Yes,
May it please, your lordship.
award.
My lord, yes. The word your lordship will find at page 51. my lord. Then more or less ex parte award.
Against you.
Yes.
You are?
I mean, not award, I mean, the order passed by the tribunal. My lord, our counsel appeared once, he filed a written statement, then he disappeared. Then without, my lord, taking into consideration the case of the bank, when the order was passed, we filed an review application that was rejected, saying that there is no provision of law to file a review application.
Why?
I don't know, my lord, the appeals court has said that power is always there. Nonetheless, my lord,
Why didn't you show that judgment?
beg your pardon.
Why didn't you show that judgment of Greenledge Bank?
Greenleaf Bank, that is the judgment, but then our lawyer was not there at all. He did not appear.
To show the judgment also.
He did not appear at all. Once he appeared, filed the written statement, and then, my lord, I don't know what happened to him. And your lordship will find the finding of the learned judge is that, my lord, the
There is a stay,
uh,
stay going on.
yes. My lord, if I take your lordships to the finding of the learned judge, your lordship will surprised to see that how he has derived the satisfaction.
So this is 2A2.
Yes. If I take your lordships to page,
So you were appointed as a part-time sweeper at so from 1/7/2009, and on Man he was posted permanently as housekeeping staff. He was terminated
yes, my lord, he
after due inquiry.
Exactly. my- Your lordship see the chart, my lord, there is a very serious chart.
Yes, which paragraph?
My
Paragraph
lord,
9.
Your lordship may see at page 53, paragraph 6, my lord.
Yes.
It is interesting to note that apart from filing of the written statement, the management did not do anything in this matter. Neither they appeared to cross-examine the workman witness, nor did they examine any witness. Hence, this line, your lordship, kindly see. Hence, whatever evidence adduced by the workman has to be considered as the materials on record. It is a matter where, after holding a disciplinary inquiry, the management dismissed the workman petitioner so and so. In his claim application, the workman said stated, now, your lordship, just for a moment. Now, the materials and record, my lord, the appeals court has clarified. Now, learned judge is construing
Yes, paragraph 9. No decision.
My lord,
No decision.
my lord, if your lordship takes up the writ petition, the
Not
matter,
necessary. Writ petition, paragraph 9.
my lord, the matter went expert. The whole case of the.
No, it's a case for remand.
My lord,
It's a case for remand for the purpose that, you see, the court, the person concerned stated that there was a departmental inquiry. And in the departmental inquiry, he was found guilty. He was given a show cause. And after the show cause, he was punished, given the punishment of termination. Where is the finding out here that the departmental inquiry is wrong?
if your lordship permits me 5 minutes time, I'll.
No.
I'll
This
satisfy.
is a case of.
My lord. Firstly, my lord, it has gone
No,
expert. My lord.
No. We have to finish it by 4:30. The order has to be signed. 4:30 order has to be
My
signed.
lord.
Third is the
My lord, lordship will grant me 5 minutes.
2 minutes.
Yes. My lord, what is the case of the management, why it has gone expert? It is a statement made in the writ petition as well as before lordship that they were represented by a lawyer and the lawyer did not go.
Forget about that.
In
I'm
fact,
not-
it is a wrong
I-
statement,
I
my lord.
am
There's no
not
lawyer
going to-
represented.
I am not, you see, when he is deciding a reference, an industrial dispute, he has to decide as to whether the termination was right or wrong. It has to be decided on the basis of whether did he took into account the disciplinary inquiry, because this is the first issue. Kindly see the first issue, whether the management area justified in ousting from his employment, whether he is justified in suspending here, departmental against there was proper or fair.
My lord.
Now, when you are having issue number 3, where is the discussion?
My lord, that is why, my lord, while lordship will grant me 5 minutes time to apprise your
2
lordship.
minutes, 1 minute now.
My
1
lord,
minute.
Lordship is aware that in a if an action is taken on the basis of a departmental inquiry and the matter is under adjudication before the Labour Court or an industrial tribunal, it is the management who has to take up a plea. Either they are relying on the inquiry in the written statement or with an additional liberty that if the inquiry is held to be bad on merit, they have to be given an opportunity.
Now, Lordship may just have a look at the written statement at page 54. It is
No.
quoted in the.
I'm not looking. I'm not looking because the court fixed an issue number 3 as regards the departmental inquiry. There is no decision on that.
Because it is the.
The court should have added these 1-2 lines out there.
My lord, Lordship.
1-2 lines
Why-
should have been here. Enough. We'll remand it.
Lordship
We
may
remand-
demand it, but at least
No.
I may be given an
No.
opportunity to. make my submission,
Enough.
my lord.
You have already taken a lot of time in the earlier matter.
No, my lord.
No, enough.
No, my lord,
Earlier.
this is something which requires an examination by.
No
your lordship.
examination. Let the labor court do. After the labor court has taken into account, and then I'm here sitting out here, I will take it.
Lordship will see that the labor court, what the labor court has said.
Labor court have stated only in paragraph number 9, nothing else.
Lordship will have a look at paragraph 11.
11? There is no 11.
Paragraph,
There is no paragraph 11.
paragraph number 8.
8 is what?
In para 11 of the written statement,
Uh,
the management stated that the workman himself acknowledged his misconduct during the disciplinary process. But the management did not even produce a prima facie proof to bring home their claim, far less to speak of proving the same as per law. However, in paragraph 15 and 16 of the claim application, that the workman admitted that he had told the work authority that the incident took place on the spur of the moment. Since the management dismissed the workman from service, it was the obligation of the management to produce the details of the disciplinary proceeding, but that was not done. In other words, the management held back all the details and awarded to the workman with the highest.
Here the burden is whom? Whose burden?
On the management.
No. Management already held the departmental
Exactly,
proceeding.
my lord. That is why I would like to,
This is a case on the 2A2.
but the provisions of the industry.
Enough.
My lord,
Enough.
lordship will see whether.
Enough. Heard Mr. S. Dr. Dalanet Senior.
Lordship may.
No.
This is.
So and so it's replacement.
My lord will,
Mr. S.
lordship will
No.
record my submission.
No.
Then what is the point in,
No point.
even if that is no point,
No
lordship
point.
will grant me 5 minutes time to place
5
my
minutes.
case.
I gave you 5. I gave you
I'm-
2 minutes. You made it 5.
Give me some time,
No.
whether the statement that the.
No.
Now, first thing, my lord, they have come against an ex parte award. First
Who?
thing, they have to establish that they were prevented by sufficient reason from appearing in the court.
Why?
It is the case of the management.
No, why? Why do we have to so?
They have said that they could not, because of the inability of the lawyer, they could not adduce evidence.
So
Now, whether a lawyer was at all engaged, lordship will have a look at the record. The written statement was filed by the branch of bank manager, and there was no lawyer. So this is out and out a false statement that because of the lawyer, we could not appear. This is out and out a false statement. Lordship will have a look at the record.
No. Where's the record?
Yes, it is there in the LCR. Lordship will see the chronological of orders,
LCR page 48, your lordship may see.
order sheet, my lord.
Order sheet, no order.
Whole statement is very cheap thing. Don't utter all this.
I do not know. The
Hold-
record-
hold your-
Now,
first of all-
if there is a wakalatnama file,
A learned friend should hold his nerve. He should not utter all these things.
don't.
Workman, lordship will have.
No. Now imposition of cost on the respondent. 10,000 has already started per minute.
Madam.
10,000.
1/4/2019, workman present, management absent. Then 14/8. Then 8/5/2000, workman present, notice not served upon the management. Then 6/6/19, workman present, management files WS through D Pal, the manager. And thereafter, nobody appeared before the court.
At page 60 of the Melod writ petition, your lordship will find order dated 12/2/2020.
Page 48 LCR সমুদ্রগুপ্ত দত্ত ওখানে তো নাই এটা told one Samudragupta Datta, my lord, was there in, your lordship may find the reflection at page 48 of LCR.
That is after the award was passed. For recalling that order, one application with the Bakalatama was filed, but not during the proceeding. So the contention that the managed bank could not proceed because of the fault of the lawyer is out and out an incorrect statement, as it is not reflected in the order sheet. Bank was never engaged. Even, my lord, the written statement which your lordship will find in the writ petition was filed by D. Pal. That is why, my lord, will see that in the award for the management, it is D. B. Pal, UBI Fund Bazaar is written. At page 49 of the writ petition, the written statement.
Okay. Okay.
Chalo,
My lord,
30,000 cost upon you.
why, my lord? Lordship will have.
You have taken 1 minute,
So,
1 minute, 10,000 into 3, 5.
now, my lord, the question is, they have made a statement. at-
Mr. Chakraborty, don't worry. I'm allowing this petition. Whatever may be, go to division bench, go to Supreme Court. I'm allowing it right now. Don't spoil the time any further. There are other councils waiting. I'm allowing it. You may say whatever may. You may just go outside and say also. Whatever may be. I'm allowing it right now.
Lordship
Take
may
that.
allow,
Take a seat.
Lordship may record my submission.
No, you tell the division bench that this court is horrendous. It doesn't record submissions of mine. Do whatever you feel like. But I'm allowing this repetition. Better over. Don't spoil any further time of this court. Leho. Heard Mr. S. Dotto, the learned senior counsel, assisted by so-and-so, who appears on behalf of the petitioner, and Mr. S. Chakraborty, who appears on behalf of the respondent number 1. Mr. K. Gogoi appears for the respondent number 2. The petitioner herein have assailed the award dated 2011-2019 passed by the learned presiding officer, Central Government Industrial Tribunal cum Labor Code Guwahati, Assam in reference case number 3/2019. Full stop. The facts which led to the filing of the instant writ petition are that the petitioner herein, the respondent number 1 herein was appointed as a part-time sweeper at Gorisagar branch, Shivsagar on 1/7/2009. And on 1/4/2016, he was posted as housekeeping cum substaff according to eligibility and governed by the terms and conditions of service in terms of the bipartite settlement. It is alleged that on 26/10/2016, one Sri Dilip Kumar Gupta, manager of Gorisagar branch, had lodged complaint against the respondent number 1 that he shouted and scolded, using abusive language against the manager, and brought an iron rod to hit the manager of the branch. It was also alleged that the petitioner, respondent number 1, threatened the life of the manager and also snatched his cell phone when the manager tried to contact the chief regional manager Shivsagar region. And all these incidences occurred in the branch. On the basis of the said incident, as alleged, the respondent number 1 was called for explanation via letter dated 26/10/2016 by the branch authority of the Gorisagar branch. And the respondent number 1 submitted a reply on 28/11/2016. Pursuant thereto, a preliminary inquiry was held, and on the basis of the report submitted on 27/10/2016, the petitioner was put under the respondent number 1 was put under suspension via order dated 31/10/2016. Thereupon, the respondent number 1 was charge sheeted. Pursuant to the said charge sheet, a disciplinary proceedings was initiated against the petitioner. Was initiated against the respondent number 1. After evidence been led, the inquiry officer submitted a report holding that the respondent number 1 was guilty of the offense charged. The respondent number 1 thereupon was furnished with the inquiry report and issued a show cause as to why punishment of dismissal should not be imposed upon him. The respondent number 1 submitted his representation, and as the representation did not find favor with the respondent petitioner, the management of the petitioner, the respondent number 1 was dismissed from service. Pursuant thereto, the respondent number 1 filed an application before the learned CGIT cum Labor Court hereinafter referred to as the Learned Tribunal under section 2A(2) of the Industrial Disputes Act 1947, for short the Act of 1947. And on the basis thereof, a reference case number 3/2019 was registered by the Learned Tribunal. The respondent number 1 filed his written statement, as well as a written statement. On behalf of the petitioner, a written objection was filed by an authorized signatory, no?
Yes.
By an authorized signatory of the petitioner. The respondent number one, on the basis of the pleadings, the learned tribunal framed as many as 5 issues, which being relevant are reproduced herein under page 553. On behalf of the materials on record having been perused reveals that none has appeared on behalf of the petitioner since the submission of the written objection. And on the other hand, the respondent number one appeared and submitted his evidence on affidavit. As the petitioner, management of the petitioner did not appear, the respondent number one was not cross-examined. The Learned Labour Court, why the impugned award dated 2011-2019, without deciding the issues which have been framed as recorded in the impugned award itself, held that the termination of the respondent number one was not justified and directed the management of the petitioner to reinstate the respondent number one to his job and pay him back wages from the date of his dismissal within 60 days from the date of receipt of the award. It is under such circumstances the present writ petition has been filed. It is relevant to take note of that this court, by an order dated 2010-2020, issued notice and stayed the impugned award dated 2011-2019. Full stop. This court have Mr. S. Dotto, the learned counsel, senior counsel appearing on behalf of the petitioner, submitted that a panel advocate of the petitioner was instructed to appear on behalf of the petitioner, but he did not appear, but the said panel advocate neither appeared nor informed the petitioner that he was not appearing in the said reference proceedings. Under such circumstances, the entire proceedings went ex parte against the petitioner. The learned senior counsel further submitted that when issues have been framed by the learned tribunal, it was incumbent upon the learned tribunal to decide the issues so framed on the basis of the evidence, which was not done, as would be apparent from a perusal of the impugned award itself. Per contra, Mr. S. Chakraborty, the learned counsel appearing on behalf of the petitioner. The respondent number 1 submitted that the proceedings have gone ex parte against the petitioner on account of the fault of the petitioner, and there is no good explanation provided before this court on the basis as to why the proceedings had proceeded ex parte against the petitioner. The learned counsel submitted that the reason so assigned is that the counsel did not appear on behalf of the respondent on behalf of the petitioner before the learned labor court, learned tribunal. But on the other hand, it was some authorized signatory of the petitioner who had submitted the bill, submitted the written statement, and thereupon, and as such, the question of that the petitioner had appointed some lawyer to represent the petitioner before the tribunal cannot be accepted. Full stop. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. Full stop. In the previous segments of the instant judgment, this court have duly taken note of that the learned tribunal, on the basis of the pleadings, have framed as many as 5 issues which have been reproduced herein above. From the perusal of the 5 issues, it reveals that there was a requirement for adjudication of facts, more particularly when the workman in his own written statement have categorically mentioned that there was a departmental proceedings, and in the departmental proceedings, the petitioner have been given, and in the departmental proceedings, the petitioner was held, the respondent number 1 was found to be guilty of the offense charged, and the petitioner was given due opportunity. And the petitioner was also further given opportunity to submit as regards the imposition of punishment. It is further seen from the impugned award that the London Labour Court had come to an opinion that there was a violation of principles of natural justice, but there was nothing mentioned as to why the principles of natural justice have been violated, why it is opined that the principles of natural justice have been opined to be violated. This court further takes note of that the learned Labour Court, instead of deciding the issues which have been formulated in a most perfunctory manner, decided the entire award against the petitioner. Under such circumstances, it is the opinion of this court that the dispute in question, the industrial dispute in question, requires a resolution in a proper manner. And as such, it is therefore the opinion of this court that this is a fit case for remand before the learned tribunal, that is the Central Government Industrial Tribunal cum Labour Court as Guwahati, to decide as to whether to decide afresh the reference case number 3/2019. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The award dated 20/11/2019 passed in reference case number 3/2019 since set aside and quashed. Number 2, the learned Central Government Industrial Tribunal cum Labour Court, Guwahati, Assam, is directed to decide afresh reference case number 3/2019 from the stage of framing of issue, from the stage after the, from the stage of providing opportunity to both the parties to adduce evidence. Puts- Taking into account that both the parties are duly represented, they are directed to appear before the learned Central Government Industrial Tribunal cum Labour Court Guwahati on 24th of November 2025.
There is no presiding officer, it is non-functional. There is no presiding officer for last 1.5 years.
Who is there?
There is no presiding officer in CGIT for the last 1.5 years.
Labour Court?
This is the central government, since it's a bank, but labor court, state labor court is functional, but this is, since this is the central government industrial tribunal,
No, this is come Labour Court Guwahati was there.
CGIT, central government.
CGIT come Labour Court.
Yes, this is the, this is the court constituted by the central government. There is a state government, the labor court constituted by the state of Assam, and there is a central government for central authorities and public sector undertakings, like banks, ONGC, oil. So the CGIT is non-functional for the last 1.5 years. The regular incumbent, after his retirement, someone joined, then he also has gone, he has gone. Nobody is there.
Not functional.
It's not functioning.
It is not functional.
It's my understanding is correct to that extent.
It is not functional.
So what to do?
That is also, I was thinking, Melody, under these circumstances, what can be the precise alternative?
I can't decide that. I can't let you to adduce evidence here.
Exactly, my lord, that's not possible also. My lord, let it go there in the meantime.
Let it go there
Yes,
and let it go there and
Lord, there may be some arrangement, my lord. Because the gentleman came here and what I could come to know that since he did not get all the facilities, he left the place.
One presiding officer was appointed. He joined, but he was not happy with the present facility there and he resigned. Then another process for recruitment was initiated, but it is
Nay,
not
he
yet
thought
finalized and
according
no
to
preside-
his
but
standard.
this is by the Labour Court also.
level
Yes,
code.
central government industrial tribunal come labor court. Now,
So
under-
this is this Minmoy Kumar Bhattacharya happens to be a AGS officer.
yes, he was registered here and after his retirement, he had joined.
AGS.
Yes, yes, yes.
So after his retirement from service, Assam service, he had joined there as presiding officer. And he was there for 5 years, I suppose, up to the age of 65 years. Now,
Appointment to auto for in the meantime.
না নেই জানি তো আমাদের ত্রিপুরার কেসগুলি তো হচ্ছে না।
Okay. On 24th of November 2025, shall be directed to appear before the learned Central Government Industrial Tribunal cum Labour Court Guwahati on 24/11/2025. The registry is directed to forthwith remit the records of the learned Labour Court to learned Labour Court to the Central Government Industrial Tribunal cum Labour Court Guwahati so that the records are available on the next date so fixed. 24th, no, 1st of December.
Lordship was fixed on 24th, 11.
First of December. 5 days.
All right. God bless you.
Yes, what is this Gauripur? Mr. Chaudhary, your matter. This Gauripur Cooperative Society.
My lord.
Urgency, no urgency. And Mr. BJ Ghosh, your matter is that matter?
Yeah.
No, these are new matters. These are the two matters, no? Okay, your matter, Gauripur, when do you want it?
As early as possible, my lord. 3.5 years have gone, my lord. The settlement is enjoyed by the other side.
You are challenging what?
On an order of settlement in favor of the private respondent.
You are appealing for? Hello?
There is no stay. There is no stay. 3 years have passed by.
2 years, 3 years he has done, another 4 years left. Hello, we end it before this year only. Let's see a bit on try our luck on 28th of October. I do 7 list the matter on 28/10/2025. And 8 and 9.
899 Lordship, actually our license is under suspension for last 2.5.
What license?
If you are by shop license,
Oh, you don't want.
my lord, so matter may fix.
How can there be a suspension from 2023-24?
Yes, it's over 20, you know. You have to file the-
Huh, Mr. Burua? How is it possible it can be under suspension?
And Lordship has also upon a past in.
There is some interim orders not to take any coercive action. Otherwise, Lordship, we have completed all the inquiry. Purpose was given, we have completed the inquiry, but because of the stay in 6053,
Both the same matter.
yeah, that item number 9, Lordship, where they have challenged the procedure of that inquiry. Lord.
Okay.
So because the stay is there, that's why, Lordship, we have not taken any.
Okay, we vacate the stay.
Okay, then we can,
Take your decision
yes, Lord.
and give it to him.
Lordship.
We vacate the stay.
My lord, I'm sorry. My lord, instead of 28th, can it be on 30th? My lord?
Inform
Yes, I will.
My lord, here in this case, one case I will challenge the propriety of the search and seizure, my lord. In that case, the stay has been granted, my lord, not to proceed with the matter. So both this case, it should hard lordship at least.
Understood.
Because my lord has already passed an order that the suspension goes beyond 90 days without any extension.
Understood, but
Yeah.
on the other hand, you are taking a stay out here. They are not in a position to take a stay.
My lord,
That cannot be a ground. No, Mr. Ghosh, no, not possible. On one hand, you take a stay, and on the other hand, you want to go by the limit of 90 days.
well, 90 days, my lord, that is prior to that, my lord, because they have already
That
suspended.
is okay, but let me therefore vacate the stay. Let them take a decision and report next week.
My lord, that, my lord, then then my lead petition will be infectious, my lord. I have challenged the propriety of the inquiry proceeding, my lord.
Why?
I have propriety of the inquiry proceeding, my lord.
What
That is-
inquiry proceedings will be there? You will be issued a show cause, they will, you submit
they
a
have-
reply matter over.
My lord, they have made an inquiry. Then inquiry without any submission of any documents, whatever it is to me, my lord, inquiry has been proceeded. So I have challenged the inquiry proceeding, my lord, here in the second lead petition, my lord.
So if you have challenged the inquiry proceedings, you cannot get the benefit of 90 days. They
Let
are not in a position to take a stand.
Let them, my lord, then let the matter be heard in the next week, my lord. Lord, you may fix the matter in the next week. Both the petition will be heard, my lord, on this, on the propriety of the search and seizure and the propriety of the selection process, my lord. No opportunity, nothing has been given to me. They have,
You have approached this court, that is the opportunity you have got.
but they have to, my lord, give me all this, then they can only proceed, my lord.
Did you raise that issue out there? That, look here, I am not in a position to
Yes, yes,
submit a
yes,
reply.
Raise the issue in the second lead petition, my lord.
Have you submitted a reply?
Yes, reply already.
My lord, reply what we have submitted. We have sought for all documents, my lord. They said it will be present at the time of hearing. Hearing, they said this is the document, my lord. Is it a compliance with the principle of natural justice, my lord? Without doing that, without furnishing us any document, they have taken the evidence of at least 40-50 people, my lord. Nothing has been given to me. Because all the matter initiated by the report of a local.
What do you need? The evidence of 40 people?
We should give a proper, that is why I
But
challenge.
your hearing is over. There's no hearing conceptualized. Is a hearing conceptualized?
No, my.
Then what are you going to do?
They have, my lord, taken a decision that my license should be cancelled. The inquiry officer.
Go and file appeal there against.
My lord, the inquiry officer has recommended, my lord, the inquiry officer has recommended that my license should be cancelled.
Save us. File an appeal. 2 matters go. with one shot.
So therefore, my lord,
The simple order of vacating the stay would now enable this court that both the matters will be finished. Only one line order is required for finishing, making, then say that the writ petition has become infructuous. They'll pass the order, na?
Yes.
no, my,
We are waiting.
sorry, my lord. Sorry. And please,
Wait.
my-
You wanted month of January.
It's up to my lord. Well, if it is possible in the December or my.
January?
May,
I'm
can it
here
be
till December.
December. If, I leave it to my lord, but if it is
Don't
possible,
leave it to me.
my lord in December or whatever, my lord in December, or November, my lord. I leave it to your lordship, my
Okay, item 8 and 9 to be listed on 11th of November.
lordship.
দেখলাম তো আমার নাম
Thirteen, 15.
ঠিক আছে কালকে দেখা হবে